All right, guys, this one might be a long one. We're going to go through the motion and all of the declarations attached to Marilyn Manson's motion to conduct limited discovery. I will give all of the context in just a second, and then we will go right into all the documents. But first, let's do our intro. Let's get into it. Oops. And welcome to Legalbytes. If you're new here, my name is Alita. I'm a lawyer licensed in California and DC, and on this channel, we explain the law one bite at a time. We don't give legal advice, but we do talk about how the law works and try to look into our crystal ball to see how things might turn out. If you're enjoying this on YouTube, we'd love it if you could like the video, subscribe to the channel, share it with friends, all the great YouTube-y stuff. And if you want to listen while out and about, we're now offering our live streams in podcast form where you can leave a rating and review. Links are in the description below, as well as to our clips channel where you can find some of the best clips taken from our live streams. Otherwise, if you want to catch me elsewhere, you can find me on Twitter, Instagram, and Facebook. And if you want to support the channel, you can do so on Locals, Patreon, or by becoming a YouTube member, or by buying some really awesome Legalbytes merch. Again, all links are in the description below. And with that said, let's get into it. All right. And here we are. I've been wanting to go over this document for a while. Obviously, this was filed a couple weeks ago. And for me, I don't know how it looks for you guys. I don't know if I'm looking kind of blurry for you, but for me, I am. And I just realized I'm still on Wi-Fi. Give me 1 second. Hopefully I don't disconnect, but I'm going to take myself off of Wi-Fi. So I'm on the Ethernet. Give me a sec. Okay. Hopefully better. Maybe not. I don't know. Let's see here. Give it a second. Give it a second. It's coming back from space. Okay. No, it is still very, very blurry. Blah. Okay. Well, at any rate, it's really good to see you guys today. Happy to see Uncivil Law in the chat. Hey, Kurt. I also saw Manson Cases is in the chat too. Bunch of folks. We got some Moz. Secret Mix Squirrel once again in the chat as well. Happy to see you here too. And I hope you're feeling better. So we've got some folks from, oh, look at this. I always love sharing these folks from Sweden. Hi, Pernilogy. Also from Virginia. And we've got, I saw one from Poland too earlier. Let's see. Where were you? I saw somebody from Poland, South Africa. We've got another Sweden. All right. All right. That's a lot. USA. Oh, and also from Chile. That's awesome. So awesome. So awesome. And Portugal and the UK. Oh, and here's Poland. There we go. Wonderful. Wonderful. And I don't think let's see here. Awesome. We could go on. We could go on forever. We've got so many great people watching from all around the world. And I always love shouting you guys out. Hopefully my connection will get better soon so that things don't look quite so grainy and blurry. But anyway, at any rate, what we're going to do first is a really quick update. Oh, yeah. Yeah. Secret Mix Girl says the chats are clear, but I am still blurry. But yeah, that is, yeah, I'm seeing that too. So it's got to be from my feed here. And I'm getting an indication that my connection is also unstable. So, yeah, I don't know what's going on with that for some reason. I'm sure it will. We've had this happen before where it just ended up clearing up on its own because there's really not anything else that I can do here. I'm not sure. Okay. Well, we're going to try rolling with it and then go on from there. Also, Lucky, thanks so much for gifting more memberships. That is so kind of you. Really, really kind of you, really generous of you. It's like almost every live stream you're gifting memberships to people. I love it. I love it. Okay. So anyway, we are going to roll with this live stream. So we are here to talk about Marilyn Manson's
motion to conduct limited discovery. What exactly does that mean? Why is this important? Why is this worth fighting about? We'll get into that first thing. But actually, almost first thing. I just lied. Right before we do that, also wanted to give a note to everybody that we're also covering the Vanessa Bryant trial, her case against the Los Angeles Sheriff Department and the Los Angeles Fire Department and a number of individuals uh, for claims coming out of the images of Kobe Bryant and Jonna Bryant um, f- uh, from the scene of their death in the helicopter accident. Obviously, a very tragic case, very sad case. It has now been combined with another case arising from the same issues, but just a different plaintiff because it's a widower whose wife died and I think also daughter also died in the crash. And trial starts tomorrow with jury selection. I really, really, really wish that I could be there in person myself, but I unfortunately will not be able to be there for it. So I'm going to be trying to keep my eye out for the headlines, any kind of news, even though, of course, if you have been paying attention to my commentary on some of the headlines on the Johnny Depp case, we can't always trust the media or the headlines, what have you. But we'll do our best, and we'll see what we can sort of parse through with the things that come out of this particular trial. Anyway, so today we're doing the motion, and then tomorrow I would like to live stream my read through of the two oppositions, the one filed just yesterday by Evan Rachel Wood and the one also filed by Illma Gore. There's a number of documents in there, and I know that folks are wanting to see those deconstructed. So we will definitely be going through that for sure. And my aim is to do that tomorrow, probably 10 a.m. East Coast time. So it'll be a little bit earlier in the day. Anyway, okay. Let us go right in. I don't know if you guys can see this now. I hope you can. I always have to wait for the delay. Yeah. Okay. So you guys can see this, I think, because I can see it on there. Okay. Also, am I not blurry anymore? Oh, look at that. Wait, hang on. I'm looking on StreamYard. Let me see for. Oh no, never mind. Okay. Okay. Anyway, let's get into it. Let's do this. Also, because there are so many documents here, I made banners for today. So, alrighty. So just so that we are all keeping track of which document we are talking about here. So right here is Marilyn Manson's notice of motion and motion to conduct limited discovery pursuant to Code of Civil Procedure, Section 425.16G, also known as the anti-SLAPP statute, and request for a continuance of defendant's motions to strike to permit such limited discovery, memorandum of points and authorities in support. Okay. So this was originally filed on the 20th. Yeah, on the 20th. And then it was refiled on the 25th after he had an ex parte hearing. I've talked about that before. An ex parte hearing is basically where one party says, hey, we need to talk to the judge as soon as possible because we need a decision on something, on an issue that if we were to go through the normal processes of setting up a hearing, getting a calendar date and having arguments with opposing counsel through papers, then by that point it'll become moot because we will the issue will have run out of time, not in our favor, and we will have been prejudiced in the litigation as a result. So anyway, they filed this like emergency motion, you can kind of think of it that way, where they go and they sit in front of the judge and they argue the next morning. And so this was originally filed with that because Marilyn Manson wanted to get a continuance for the discovery dates or for the anti-SLAPP hearings because he wanted to conduct some limited discovery. So right now, what is happening is the anti-SLAPP deadline has been pushed back a little bit so that they can go back and forth on this specific issue on discovery. Why is discovery an issue right now in the Marilyn Manson case? The reason for that is because because Evan Rachel Wood and Illma Gore have filed an anti-SLAPP motion, not just a normal motion to dismiss, but specifically a special motion to strike. This is a very unique motion that gets filed. It's designed to protect constitutional rights and to prevent people from improper litigation, just to prevent people from speaking out or petitioning their government, or sometimes, sometimes you can have a lawsuit against a law firm for representing someone that also is included in the universe of anti-SLAPP cases. So what happens here is immediately once an anti-SLAPP motion is filed, then the discovery gets frozen. The entire case gets frozen until this anti-SLAPP issue is resolved. And the reason for that is because California courts take anti-SLAPP very, very, very seriously. It's not like in Virginia, if you were following the Depp v. Heard case, where there was an anti-SLAPP motion, but that was decided at the end of trial. It is not done that way in California. It is the very first thing. It's immediate, everything shuts down until that's figured out. So, and the reason for that is that if in fact what has happened here is the plaintiff has filed this litigation just to try to infringe the defendant's First Amendment rights. They're just trying to prevent them from speaking out or from, doing whatever, as opposed to a legitimate defamation claim. So if that in fact is the case, then it sort of defeats the purpose of the anti-SLAPP motion if they were to allow them to proceed with discovery and all this other kind of stuff, because the whole point of it is to sort of not immunize the defendant, but to insulate the defendant from improper litigation. So why should they have to pay for this discovery and all this other crap that they otherwise shouldn't have to, because they're just using their constitutional rights, or they're exercising their constitutional rights. So what is happening here is Marilyn Manson is requesting a very specific kind of request to do discovery. And so in order for him to get discovery under this umbrella of an anti-SLAPP motion, it has to be specifically so that he can respond to the anti-SLAPP motion. And so there are certain types of circumstances where it's actually appropriate for a plaintiff to say, hey, I actually need to depose the defendant on this, or I need to request documents of a third party because I don't have this information. And in order for me to have a chance to meet my burden to respond to this anti-SLAPP motion, I need to be able to have access to information, because it also has to be, it's sort of like returning some fairness back to the plaintiff after, anti-SLAPP is very protective of the defendant in that particular circumstance. Sometimes, you have to allow them a certain amount of leeway to request information so that the plaintiff can actually respond to it. I hope that makes sense to you guys. So what's happening here is he's requesting exactly that. So we're going to get into the specific arguments, but I anticipate that he's going to be saying, hey, I have a certain burden to meet here, and I don't have access to this information. And the only way that I can possibly meet my burden to prove a prima facie case so that I can overcome the defendant's motion here is with a certain amount of discovery. And I'm going to keep it very narrowly tailored to these specific issues. I'm not going to conduct crazy amount of discovery to request all kinds of information of the defendants. I'm not going to depose them on the actual case, but just on these specific, very narrow issues. So, okay. With that, let's continue, and I will, try to zoom in. I should have zoomed in a little bit better earlier. Okay. All right, we'll skip the notice. We don't need that. All right. So we can see here the table of contents, introduction, relevant facts, and procedural background. Okay. And then the argument. The court may permit discovery to defeat a special motion to strike. There's good cause to allow the requested discovery. And these are all of the reasons why. Okay. Let's skip ahead. All right. Memorandum of points and authorities. This is where we get into the actual arguments. Okay. Introduction. Section 1, introduction. Plaintiff Brian Warner, professionally known as Marilyn Manson, plaintiff or Warner, seeks an order permitting him to conduct limited and specific discovery so he can obtain the admissible evidence that will allow him to defeat the two separate but overlapping special motions to strike filed by defendants Evan Rachel Wood and Ashley Gore, aka Illma Gore, which challenged some but not all of the causes of action in his complaint. Good cause exists to allow the discovery requested, namely the depositions of two party witnesses, Wood and Gore, and three non-party witnesses, FBI agent Michelle Langer, Michelle Meyer, and Catherine McGaffigan, who possess admissible facts and information that are not available to Warner, but nevertheless necessary to make a prima facie showing of the unchallenged claims. In light of the court's sua sponte order, advancing defendants' motions by several months, Warner further respectfully requests the court continue the currently scheduled hearing dates to allow sufficient time for Warner to conduct the requested discovery and oppose the motions as is authorized and encouraged under California statute and decisional authority. Relevant facts and procedural background. Wood and Warner were romantic partners over 12 years ago, during a time Warner was known for his public shock rocker persona and spirited rock and roll lifestyle, and Wood, a famous actress, was known for being Warner's wild partner who, despite having a healthy, loving relationship with Warner, craved danger and excitement. Since then, Wood has attempted to rebrand and distance herself from Warner. But simply living her own life was not enough. Rather, in recent years, Wood and her on-again, off-again romantic partner Gore conspired and wrongfully caused women to make false public accusations of rape and sexual abuse against Warner. Gore, a serial fraudster, sought to make money and raise her esteem with Wood. Gore and Wood weaponized Wood's influence and celebrity status, lies about Warner, and threats of fictitious government investigations to lure in would-be accusers, whilst engaging in outrageous and illegal acts to implant, secure, distribute, and amplify highly coordinated public falsehoods against Warner. While many women refused to engage, some did not. For example, one has since shared online that they told me to lie and act, stating further that she never wanted to cancel anyone, but just fell in with influence. One of the things that I look for in reading any of these motions or any of these filings or whatever are citations for all of these things. So you can see here pretty much throughout this whole first paragraph, they've been citing to the complaint or to, I think, Warner's, I believe Warner's declaration, or no, it has all been from the complaint. I wish that I had a citation here for this one right here about they told me to lie and act. So we'll see if that gets if the backing, the underpinning for that shows up throughout. Otherwise, that will remain a question to me. On March 2nd, 2022, Warner sued Wood and Gore for intentional infliction of emotional distress, IIED, defamation per se, violation of the Comprehensive Data and Access Fraud Act, and impersonation over the internet. The complaints IIED and defamation causes of action arise in part out of Wood and Gore, 1, falsifying correspondence from a real agent of the Federal Bureau of Investigation, which falsely claimed that agent was investigating Warner and that Wood and other victims of Warner were in danger, an act of forgery witnessed by Gore's twin sister. 2, defaming Warner by stating he filmed the sexual abuse of a minor who is dead. And 3, causing multiple women who only ever had consensual relationships with Warner to falsely accuse Warner of rape and abuse. In response to the complaint, Wood and Gore filed separate but overlapping special motions to strike pursuant to Code of Civil Procedure Section 425.16 on the grounds that these three categories of particular conduct constitute protected activity, and Warner cannot establish a probability of prevailing on his IIED and defamation causes of action arising therefrom. The gist of defendant's argument with respect to the fake FBI letter is that Warner cannot show a probability of prevailing because 1, their conduct was not outrageous. 2, they did not possess the requisite intent. 3, the letter contained no false statement. And 4, the fake letter is protected by the litigation privilege, as according to Wood, she also filed it in a California family law proceeding. With respect to the falsehood that Warner manufactured child illicit material, defendants contend Warner's claim fails because 1, the statement is not outrageous. 2, Wood did not make that statement and did not conspire with Gore. And 3, neither possessed the requisite intent, i.e. actual malice. Lastly, as to defendants having pressured women to come forward and lie that Warner raped and abused them, defendants contend 1, they never pressured anyone to make false allegations. 2, they made no false allegations. And 3, their communications are protected by the so-called common interest privilege. While a discovery stay was automatically imposed by statute when Wood and Gore filed their motions, many of the facts supporting the validity of Warner's claims and rebutting defendants' arguments have already come to light. All right, and here's where they're going to cite to some declarations. The impersonated FBI agent, Michelle Langer, confirmed to counsel for Warner that she did not draft, sign, or authorize Wood and Gore's fabricated letter and was never involved in any investigation of Warner or Wood. Damning if true. I'm not going to lie. That is fairly damning if true. In late 2020, Gore and Wood exchanged draft language for the fake FBI letter over the Signal app. Okay, citing to Briton Gore's declaration. In early 2021, Gore's twin sister witnessed Gore forge a signature on the fake FBI letter. The telephone number Gore and or Wood put on the letter did not belong to the real but impersonated agent. And when Wood was informed that people she had given the letter to or told about the quote-unquote investigation and attempted unsuccessfully to contact the agent, Wood did not correct the letter. When Gore's twin sister told Wood in late 2021 that she witnessed Gore doctoring the fake FBI letter earlier that year, Wood would only muster, think of what would happen if this ever got out to the media. Yeah, there's a lot here so far that if this is true, would be fairly damning, particularly for the IIED claim against both Illma Gore and Evan Rachel Wood. All right, at least one of Warner's public accusers shared with a third party online that she made her false allegations against Warner, including in TV and magazine features and a civil complaint, only after succumbing to pressure by Gore, Wood, and their co-conspirators to do so. Okay. That also would be fairly damning for that point. At least one woman confirmed that Gore pressured her to join a victims group put on by Gore and Wood, but she did not join because she was not a victim. When she did not join, Woods and Gore's co-conspirators claimed the woman had been victimized anyway. Multiple accusers have confirmed that until they were tainted by Gore and Wood, they had no quote-unquote memory of abuse. Rather, Gore and Wood, quote, unlocked new memories, unquote. And the accusers, quote, learned from other participants, unquote, and Woods and Gore's groups, unquote, quote unquote, the acts that they would later claim Warner did to them. Okay. Gore publicly confirmed that she authored the checklists and scripts attached to Warner's complaint that were provided to prospective accusers and listed the specific acts of alleged abuse such accusers were encouraged to and would claim against Warner. Gore has not denied spreading the falsehood that Groupie was child illicit material, and she attempted to recruit teenage survivors of violence by claiming she and Wood knew of and were speaking about Groupie, a so-called similar experience. And The professional actress who starred in Warner's claimed child illicit material, which was in reality a staged horror film with no explicit sex scenes entitled Groupie, confirmed that she was at least 21 years old during filming, was not abused, and considered it a paid acting role. When Wood filed her special motion to strike on April 28th, 2022, and Gore filed hers on May 24th, 2022, following a stipulated extension, they noticed hearings for December 13th, 2022 and January 31st, 2023, respectively. Warner understood and relied upon the fact that he would have several months to collect and organize the admissible evidence needed to defeat defendants' motions, and where additional evidence was needed but not available to Warner, such as evidence regarding Wood's and Gore's intent, to file a notice motion seeking an order to lift the automatic discovery stay. However, at the July 6, 2022 case management conference, the court ordered sua sponte, meaning the court ordered on its own motion, not requested by either party, that Wood's hearing be advanced to August 18th, 2022, and Gore's to September 13th, 2022, compressing the time Warner had to oppose the motions to just a matter of weeks, given that the first opposition will be due August 5th, 2022. So in other words, when Evan Rachel Wood and Illma Gore first filed their anti-SLAPP motions, they were given hearing dates for December 13th, 2022 and January 31st, 2023. And the court on July 6th, when they had a case management conference, which is basically, it's like a routine housekeeping hearing that they have in these cases, just to where the judge basically tracks the litigation to see, is it progressing? What needs to happen? Do I need to send you guys to mediation so you can settle this case? That's usually one of those things that happens. And so these case management conferences are very routine, and like I said, they happen periodically throughout the litigation. So on July 6th, they had one of these case management conferences. So the judge saw that the hearing dates were way far out in December and January of this year and next year. And so the judge basically said, well, those are really far out. Those are supposed to be, generally speaking, within 30 days of the filing of the motion. Generally speaking, that is true. However, they can be pushed back for good cause, for good reasons. So anyway, so that's what happened. That's why the hearings went from December and January to August and September. And so what Warner said is that no one was anticipating that that would happen, and so therefore they need extra time so that they can properly respond to the anti-SLAPP motion. And generally speaking, courts don't like one side winning on a technicality. So something like that is, like, generally speaking, I would expect that to be granted. I would expect courts to give a little bit of extra time so that people can do the things that they need to do, so that their arguments can be heard on their merits as opposed to out of technicalities. All right, part 3, argument. All right. A, the court may permit discovery to defeat a special motion to strike. It is, in some circumstances, an available tool. So let's get into the legal citations for what circumstances those are and what the rules are for that. Code of Civil Procedure, section 425.16a, again under the anti-SLAPP statute, provides a procedural remedy to dismiss at an early stage only frivolous actions that chill the valid exercise of the constitutional right of freedom of speech. Yes. So just because an action invokes the Constitution doesn't necessarily mean that it's going to be dismissed under the anti-SLAPP law. Remember how there's 2 prongs to the test. And I just remembered that I was totally going to link the anti-SLAPP videos that I've already done on this. The one going through the motions filed by Evan Rachel Wood and Illma Gore, and my other follow-up video on my later thoughts on it. I was going to link those in the description below for people that want a deep dive on anti-SLAPP law. If you have not, I should have said this at the beginning. If you don't know what anti-SLAPP law is, I'm not going to go through it again in this particular video, but I will link in the description the 2 videos that I've done that sort of go into it, and you guys can check those out first and then come back to this one, because you kind of have to understand that sort of foundation before really jumping in. Okay, anyway, let's go on. Thus, even where a moving defendant carries its burden establishing that claims at issue from an yeah, sorry. let me say that again. Thus, even where a moving defendant carries its burden establishing that claims at issue arise from enumerated protected activity, a plaintiff with non-frivolous claims can defeat the motion under the second prong of the anti-SLAPP statute's two-prong test by showing a probability of success on the challenged claims. So basically what I just said. Section 425.16b1 B1's probability standard is not high, and a plaintiff only needs to show a minimal level of legal sufficiency and triability. In other words, only a case of minimal merit. And then citing to Comstock v. Aber, see also Navalier v. Sletton, where they say that only causes of action lacking even minimal merit may be stricken. In analyzing the second prong, courts accept as true all evidence favorable to the plaintiff and assess the defendant's evidence only to determine if it defeats the plaintiff's submission as a matter of law. So, this is an important point here. Courts accept as true all evidence favorable to the plaintiff and assess the defendant's evidence only to determine if it defeats the plaintiff's submission as a matter of law. So, if there's any kind of a gray area, muddy middle goes to the plaintiff. In other words, muddy middle goes to this motion, the anti-SLAPP motion getting struck down, and the lawsuit continuing forward. And this is an important point too that I mentioned before, that it bears repeating here as well, that he doesn't necessarily have to prove he doesn't have to prove the defamation cause of action. He doesn't have to prove the IIED cause of action at this point. He has to prove that he has a probability of being able to prove it later. In other words, he's got to show some homework to show that he's got something there that a jury could potentially find in his favor, possibly. So if there's any kind of a gray area with any kind of facts, that goes in favor of Manson. While filing of an anti-SLAPP motion automatically stays discovery, Section 425.16G provides that the court, on notice motion and for good cause shown, may order that specified discovery be conducted. Good cause meaning they've got to have a good reason. Good enough reason that it's worth overcoming this need to sort of insulate defendants from improper lawsuits. The court's ability to lift the stay counterbalances the procedural requirement of forcing a plaintiff to make an evidentiary showing without the benefit of discovery, citing to Schroeder v. Irvine City Council, where it says denial of discovery can adversely affect due process rights by placing the burden on the plaintiff to show a prima facie case without permitting the collection of evidence needed to satisfy that burden. Exactly. It's just balancing the scales. When somebody has a particular burden, whether we are talking about the case at large, the entire litigation, like plaintiffs have a burden of proving their case, or whether we're talking about in a more limited sort of issue here, where we're talking about an anti-SLAPP motion, where the plaintiff has a burden of making some kind of a showing, courts are generally speaking going to say, yeah, you have the ability to conduct discovery or have some sort of leeway in whatever circumstance we're talking about so that you can actually prove that. In this context, good cause requires a showing that the specified discovery is necessary for the plaintiff to oppose the anti-SLAPP motion and is tailored to that end. So, in other words, it's got to be something that he needs to meet the burden, his burden for purposes of the anti-SLAPP statute, and it can't be more than that. It's got to be very, very specific. What the information that he is requesting and the kinds of information and also the manner of information request, document requests, depositions, that kind of thing, that all has to be narrowly tailored to this particular issue of just meeting his burden for the anti-SLAPP motion. Going back to the motion here, where evidence necessary to establish the plaintiff's prima facie case is in the hands of the defendant or a third party, that fact goes a long way towards showing good cause. That's a good point right here. And this is an appellate case right here from 2004. It's not well, I guess it is a little old now. Oh, that's weird. 2004 was how many years ago? 18 years ago? Holy crap, I feel old. Anyway, aside from that, this is a very good point for Manson right here, that where evidence necessary to establish the plaintiff's prima facie case is in the hands of the defendant or a third party. In other words, in order for Manson in this particular case to prove that he has a probability of winning the IIED claim on the one hand, the defamation claim on the other, the information that he would need in order to make that showing is in the hands of the defendant or some kind of a third party. Generally speaking, courts are going to look at that and say, all right, you have the ability to request some discovery, because we don't expect a plaintiff to have all of the information from the very beginning, from the get-go, when they file their complaint from the very beginning. So, and that's one of the reasons why we have such a low pleading standard in the American judicial system, where, to file a complaint, to start a lawsuit, you really don't need too much. You just need some plausible claims. You don't need to have any actual evidence on hand in order to file a lawsuit. Now, it can get thrown out fairly quickly after that if you don't, and if you don't find any. But that's basically, like, there's no expectation that the plaintiff have all of the information, where it's to be reasonably expected that that particular information would be in the hands of the defendant or some third party. And thus, if the plaintiff makes a timely and proper showing in response to the motion to strike that a defendant or witness possesses evidence needed by plaintiff to establish a prima facie case, the plaintiff must be given the reasonable opportunity to obtain that evidence through discovery before the motion to strike is adjudicated. Citing to Lafayette Morehouse Inc. v. Chronicle Publishing Company. Some of these shortened names, they escape me sometimes. But at any rate, it's an appellate case from 1995. There we go. And on civil law, thanks for the super chat. He says, lies, 1995 was 7 years ago. Definitely not true. And I've been tracking the other super chats, so I'll get to those in just a second, guys. So, and they cite to Lafayette Morehouse Inc. saying, holding courts must liberally exercise their discretion by authorizing reasonable and specified discovery timely petitioned for by a plaintiff. Yep, exactly. That looks like good law. Okay, before we get to B, where he says there is good cause to allow the requested discovery, let's get some super chats here. Brooke Cormier, thanks so much for the super chat. Says LB needs a graphics update. She is slipping back into 8-bit territory. LOL. I know. For whatever reason, I don't know. Something's up with my camera today, but at least the document is clear. Like, that's the most important part, is I want you guys to be able to read the document. So at least there's that. Who cares about me? Okay, Colonel Kurtz, thanks so much for the super chat. I appreciate it. Uncivil Law says, why can she slap? You're very funny. You're very, very funny. And Shireen Robson, welcome to Bite Club. Thanks for becoming a Bite Club member. And also, same thing with Nosy Neighbor 99. Welcome to Bite Club. Happy to have you guys here for sure. Alrighty. Okay. Let us get back to the motion, part B, where he says there is good cause to allow the requested discovery. All right. The court should, it's a little bit of a typo here. It should say exercise its discretion. The court should exercise its discretion pursuant to section 425(16)G and allow Warner to obtain the limited and specified evidence needed to establish his prima facie case and respond to the claim deficiencies identified in Woods and Gore's special motions to strike. Appendix A attaches here to sets forth the discovery Warner seeks to support the portions of his IIED and defamation causes of action subject to Wood's and Gore's motions. For each of the three categories of conduct at issue in the motions, Appendix A identifies 1, the claim elements Wood and or Gore appear to challenge; 2, the type of discovery that Warner seeks to respond to those challenges; 3, the admissible facts and evidence Warner expects to elicit through such discovery; and 4, the reasons Warner cannot obtain such discovery elsewhere. This more than sufficiently demonstrates that good cause exists to permit the limited discovery requested. That's actually very, very useful. So, we'll read subpart 1 here in just a sec, but I'll just show you guys really quickly Appendix A. Okay. You can see I've got to zoom out just a little bit here. Okay, here we go. So, for example, here, Appendix A, it says claim was the fake FBI letter for IIED. Claim issue, outrageous conduct and falsity. And then requested discovery would be deposition of Agent Michelle Langer, deposition of defendant Ashley Gore, aka Illma Gore, deposition of Evan Rachel Wood, deposition of third party Michelle Meyer. Okay. And then they go through very specifically saying, 1, Agent Langer was not involved in any investigations involving Wood or Warner. 2, Agent Langer did not draft, sign, or authorize distribution of letter purporting to have been drafted by, signed by, and authorized for distribution on behalf of Agent Langer. 3, Agent Langer never discussed the fake FBI letter with Gore or Wood. 4, the Federal Violent Crimes Department is not a real department of the FBI or affiliated with Agent Langer. 5, circumstances under which Gore became aware of Agent Langer. And then availability of information. In other words, this column right here on the far right is why he says that he can't get that himself. It says admissible evidence uniquely available to person from whom discovery is sought and not available to Warner. Warner could not obtain declaration from the third party. Yeah, they probably reached out to Agent Langer at the FBI and said, "Hey, will you sign a declaration?" They probably said, "No, the FBI won't let me," or "No, I don't really want to unless I'm required to by some form of a subpoena." And which then puts Marilyn Manson in this specific predicament to say, "Look, I know that all of this is to be the case because we've had conversations with her, and yet she is not willing to sign a declaration because of her position at the FBI or something, whatever reason. She doesn't even have to have like a very strong reason. She could just say, no, I don't have to because I'm a third party and I'm not required to participate in your litigation." So, okay, that's just an example here. We're not going to go through all of those specifics here, but I will go back up. All right. Okay. Part 1. The requested discovery is narrowly tailored and responsive to the special motions to strike. The discovery Warner seeks is narrowly tailored to the prima facie showing he must make in response to Woods and Gore's motions, and then citing to Paula affirming grant of pre-hearing discovery. The facts and motion and information Warner seeks discovery of are specified in Appendix A, and each supports one or more elements of his causes of action. See Sipple v. Foundation for National Progress, where it says plaintiff must explain what additional facts he expects to uncover or why the requested discovery is necessary to carry his burden. Moreover, every piece of discovery Warner seeks targets only those elements necessary for him to make a prima facie showing on the challenge causes of action and no more. See 1-800-contacts. Oh, this is a little bit of a typo. See 1-800-contacts Inc. v. Steinberg, where it says requested discovery may not extend beyond the elements of a prima facie case. Exactly. It has to be narrowly tailored. It has to be requesting information that you need for the anti-SLAPP motion and the anti-SLAPP motion only, nothing else. And then they also cite to Mattel Inc. v. Loose Forward Hamilton and Scripps, where it says further discovery should be limited to the issues raised in the special motion to strike. Yep. Subpart 2, I should say, the requested discovery is not otherwise available to Warner. The critical discovery items Warner seeks are not in his possession or control. Rather, they are possessed by the persons from whom he seeks discovery. Because Wood and Gore challenged Warner's defamation and IIED claims on the grounds Warner cannot meet his burden to show Wood and Gore possessed the requisite state of mind/intent, allowing Warner to take discovery on these claim elements are of prime import, given that Wood and Gore will generally be the principal, if not the only source of evidence concerning such matters as whether they knew the statement published was false or published the statement in reckless disregard of whether the matter was false and defamatory, or acted negligently in failing to learn whether the matter published was false and defamatory. It's true. I mean, uh, that is true. Where we are talking about someone's intent, someone's state of mind, no one else, like if we are talking about the rules of evidence, for example, Manson's attorneys can't ask someone else what was in Illma Gore's brain at the time that she talked about the groupie video, right? They can't ask someone else about what Evan Rachel Wood was thinking, when she was using the FBI letter at various points in time. They have to ask them for that. And then the question becomes whether or not their responses are convincing. And the thing about that is that, if there is enough there to create a gray area, as I said before, muddy middle goes to the plaintiff on this issue. The requested depositions are also needed to authenticate documents Wood, Gore, and others sent, received, and or created so Warner can present evidence establishing a prima facie case that will ultimately be admissible at trial, citing Sanchez v. Bezos, which is a very recent case, which says, while plaintiff need not establish all preconditions to admissibility at the anti-SLAPP stage, evidence may be considered if it is reasonably possible, in italics, will be admissible at trial. And then it also cites to Fashion 21 v. Coalition for Humane Immigrant Rights of Los Angeles, where it says, court properly considered videotape evidence in second prong analysis, given the high probability plaintiff would succeed in offering the videotape into evidence at trial and the minimal showing necessary to overcome a SLAPP motion. The automatic discovery stay imposed when Wood and Gore filed their motions has prevented Warner from issuing written discovery or deposition notices and subpoenas to Wood, Gore, or anyone else. Wood and Gore have declined to voluntarily sit for depositions in advance of Warner's opposition, or even provide dates they could be available if the court so ordered. I can just imagine, the conversation over the phone or by email between the two lawyers on this, or I guess three lawyers, because Illma Gore has her own legal team. But between the two sides, where Marilyn Manson's lawyer writes an email saying, "Hey, is your client, willing to sit for a deposition?" And the answer is, of course, no. not if they're not actually required to because of the anti-SLAPP statute. So why would they voluntarily sit for that? But even if you know that the answer is no, you kind of have to ask it anyway, because you have to show that they have refused to do so voluntarily. Warner has also diligently attempted but been unsuccessful in obtaining declarations from the non-party witnesses that he seeks leave to take discovery from. That said, at least one of the third-party witnesses has stated she is amenable to being subpoenaed for a deposition if so ordered by the court. The request is timely. Warner timely brings this request for limited discovery. When Wood and Gore filed their motions in April and May 2022, they noticed hearings for December 2022 and January 2023, respectively. Based on these dates, Warner reasonably relied on the fact that he had at least several months not only to organize and marshal evidence supporting his prima facie case, but also to file a regularly noticed motion pursuant to section 425.16G. were he to need additional information. In advance of the July 6, 2022 case management conference, no party discussed advancing, let alone sought to advance the hearing dates. So in other words, no one asked for it. No one asked for this for these hearings to be bumped up. The judge did it on their own. However, at the conference, the court sua sponte, of its own motion, without the request of any other parties, what that means, sua sponte, advanced the hearing dates by several months, requiring Warner to file his opposition and seek any and all Section 425.16G discovery by August 5th, 2022. Warner filed his request, and on an ex parte basis per the court's guidance, as soon as was reasonably practicable to do so following the July 6th conference, given the factual showing required to substantiate such a request. 4, the discovery. And I will say, looking at this, no, I mean, looking at the timeline of things, that it makes perfect sense to me. No, I think that, like I said before, courts are generally like unless the circumstance where the court would say no is if it's like literally the day before the hearing, the anti-SLAPP hearing, or it's like the day before their opposition would be due, and like they had months and months and months and no one acted on it and no one moved any of the dates or anything, right? Like if we were all the way up in like November, December, and all of a sudden Manson was like, oh, hey, those hearings that we've got in December, January, assuming of course that the court didn't move those to August and September, and then he says, oh, hey, those hearings, well, we need to push those back even further because we need to conduct discovery. Then you would probably have a timeliness issue. But here, where we've got July 6th and then him responding within a week or two of that July 6th hearing, it takes time to draft these kinds of motions. It takes time to put together these declarations, and there's 8 declarations attached to this particular motion. So I do remember that in the ex parte stage, reading the opposition by Evan Rachel Wood and Illma Gore, by their attorneys, that they were trying to say that it was not timely because they waited a full 14 days. That's an argument that I would expect them to make, just because it's the kind of shade that gets thrown back and forth during litigation. But that's not a very persuasive argument because of the fact that like judges understand that these things take time to write. So it's still within a reasonable window, I would say. Okay. So yeah. So basically all of that is to say that for part 3, the request is timely. I would agree. that this motion is pretty timely. 4, the discovery is not precluded as a matter of law. Neither Wood nor Gore have raised any meritorious challenges to the pleadings that would render the requested discovery irrelevant as a matter of law, i.e., that even with the benefit of the requested discovery, Warner still could not establish a probability of prevailing at trial. Wood contends in her motions that the IIED claim arising from the forged FBI letter is barred by the litigation privilege. A privileged publication, and then it cites to Civil Code Section 47B, where it says a privileged publication or broadcast is made in any 1, legislative proceeding, 2, judicial proceeding, 3, in any other official proceeding authorized by law, or 4, in the initiation of or course of any other proceeding authorized by law. But this argument does not and cannot preclude discovery. While Gore fails to even address the letter she forged, Wood mischaracterizes and misquotes Warner's cause of action and the conduct from which it arises. It is not Wood's filing of the faked letter in a March 2021 family law proceeding that is the gist of Warner's claim, as Wood contends, but rather their forging of the letter in November 2020 and their impersonation of Agent Langer, invention of an ongoing FBI investigation, and using these things as tools to cajole, pressure, and coordinate others to falsely accuse Warner of sexual abuse. The complaint's IIED cause of action unmistakably draws this distinction. Gore's and Wood's conduct was outrageous in that it was so extreme as to exceed all bounds of that usually tolerated and civilized community. This conduct included falsifying correspondence from a fictitious federal agent claiming that there was concern for the safety of Wood, other alleged quote-unquote victims of Warner, and their families, as well as an ongoing federal criminal investigation targeting Warner. And then see also from the complaint, Wood's and Gore's wrongful conduct in furtherance of their conspiracy is staggering. They impersonated an actual agent of the Federal Bureau of Investigation by forging and distributing a fictitious letter from the agent to create the false appearance that Warner's alleged victims and their families were in danger and that there was a federal criminal investigation of Warner ongoing. Even a cursory comparison of Warner's complaint to the select portions relied on by Wood bears this out. Alrighty. Comparing the complaint cited by Wood, motion at 11. In addition to the crimes detailed above, Wood submitted the forged letter in a California custody proceeding. Wood cannot dispose of Warner's IIED claim by misrepresenting it. Citing Burrell v. Schnitt, where it says allegations of protected activity that merely provide context without supporting a claim for recovery cannot be stricken under the anti-SLAPP statute. So I would agree that, to me, it seemed like the addition of information of her use of the letter in the custody matter appeared to be, from the complaint, it appeared to be, you could say, vestigial, right? The way that it was drafted was, that was one of the things in the factual allegations that he said. However, there were other reasons that he said that the FBI letter that he says was forged gave rise to an IIED claim, and that was the use of that with the other women as an example. And then it also cites to Sprengel v. Zbilut, I think, saying the trial court must focus on the substance of the plaintiff's lawsuit in analyzing the first prong of a special motion to strike. Moreover, given that Woods and Gore's forgery of the FBI letter and unauthorized impersonation of Agent Michelle Langer is illegal under multiple criminal statutes, it is highly remote the court would even analyze the FBI letter under prong 2, instead disposing of Wood's challenge to this conduct at the first step. Citing to Lefebvre v. Lefebvre, where it says illegal activity is not a constitutionally protected exercise of the right to petition or free speech, ending the anti-SLAPP motion. And we talked about this when I was going over the anti-SLAPP motions last week as well, that this is true. This is case law that I independently found as well, saying that illegal activity is not a constitutionally protected exercise. And then it also cites to Oasis W Realty LLC v. Goldman, saying where a defendant fails to make a threshold showing that the causes of action arose from protected activity, there is no need to address the second step of the anti-SLAPP inquiry. For example, it is a federal crime to falsely assume or pretend to be an officer or employee acting under the authority of the United States or any department, agency, or officer thereof, regardless of Woods or Gore's claimed purpose for doing so. United States, and then it cites to United States v. Wade, which says an intent to defraud or deceive is not a separate element of Section 912. False personation and forgery are also crimes under California law. The purpose of making this point here is merely to show it would not further the purpose of the anti-SLAPP statute to uphold the stay and deny discovery where defendants are unlikely to prevail in any event. So, for me personally, I think that Evan Rachel Wood does have a point where the document was used for purposes of litigation, even if it turns out that that was perjury. There's case law saying that document would still fall under anti-SLAPP under the litigation privilege. So I'm not entirely convinced by this whole argument. They've got some good points, but I'm not entirely convinced, to be honest. But let's see what they have to say about the other privilege that that Evan Rachel Wood has asserted as to the FBI document. Separately, Wood contends the IIED claim arising out of communications among Warner's victims is barred under the common interest privilege, citing to Civil Code Section 47C, where it says a privileged publication or broadcast is one made in communication without malice to a person interested therein, by one who is also interested. But this argument cannot and does not block the requested two-pronged discovery either. Just the opposite, Wood's invocation of this privilege actually bolsters Warner's request for specified discovery. Whether Wood and Gore communicated without malice is an inherently factual issue, evidence of which is principally known to Wood and Gore. I would agree. I would agree with that. That if they are saying that all of these women had, I mean, number one, if they say that all of these women had a common interest together, right? They were interested in the same thing. They were interested in coming forward and accusing Marilyn Manson of abuse that they actually had happened to them. That is one thing, but that's a factual issue. So if they are going to assert that, he arguably needs the ability to request some discovery to rebut that. They've opened the door to that conversation, in other words. The argument also fails because there is no evidence establishing this privilege applies as a matter of law. Gore does not offer any declaration or admissible evidence with her motion, and Wood's vague declaration fails to nullify Warner's claim that women who were never abused by Warner were pressured to and did make false accusations they were. And then they point to Evan Rachel Wood's motion saying arguing communications made to process the abuse inflicted by Warner. And then also Wood's declaration to the point where it says, we respected the wishes of people who did not want to be filmed or did not want to appear in the documentary. Indeed, at least one of Wood's and Gore's co-conspirators, Ashley Morgan Smithline, has already admitted to a third party online that they told me to lie and they let me be the patsy and take the worst. Okay, so that was the part earlier where I was like, I don't see a citation to a declaration or anything here, but now we do. That would be the Skya declaration. So when we do get to that, that'll be very interesting to read. She even admitted being under the influence of illicit narcotics during press appearances because they destroyed me and I had to be numb. And yet other women have said they would not be pressured by Gore and Wood to come forward with stories that were not true. And then it cites to the Balog declaration. Balog. I hope I'm pronouncing that correctly. I always hope I'm pronouncing these things correctly. At the very least, it would be premature to determine now as a matter of law that the common interest privilege applies in order to block Section 425.16G discovery. I would agree. If this were a situation where they do have a common interest that could potentially block litigation like this, for this particular claim having to do with the FBI letter as to the women working together. But if this is true, if Ashley Morgan Smithline did in fact say this, that's particularly damaging. That could be enough to overcome the anti-SLAPP motion as to the FBI letter. Same thing. This also helps. The other women who have said that they would not be pressured by them and they decided not to participate. We'll see these declarations as we go on. Part 5, subpart 5. Warner will make a prima facie showing on each of the challenged claim elements. Okay, so here he goes. Wood's and Gore's undeveloped and superficial contentions that Warner will fail to establish certain other claim elements cannot block discovery. All Warner must demonstrate on these elements is a prima facie showing. He can do this and more, especially where, at this stage, the court does not weigh evidence or resolve conflicting factual claims. Absolutely. Like I said, muddy middle, gray area, the gray zone, that goes to Brian Warner. And here's a good question. Helen Hu says, what is prima facie on its face? So basically saying that take, for example, an IIED claim. There are a certain number of elements that Brian Warner has to meet in order for his complaint to survive, to move on into the litigation. And then at trial, he has to actually prove all 4 of those elements in order to win the particular case against Evan Rachel Wood. and against Illma Gore. So at this stage, when they're saying that he has to make a prima facie showing, he has to make a showing that on its face that there's enough there, he can at least check a box for each of those elements. All right. IIED, fake FBI letter. Warner can show he suffered severe emotional distress caused by Woods and Gore's wrongful conduct, including forging the FBI letter. Indeed, Wood and Gore used this letter as a tool in their larger conspiracy to cause harm to Warner, including in conjunction with wrongful conduct that neither Wood nor Gore have challenged in their motions, such as hacking, swatting, and impersonating Warner. That will be subject to further litigation regardless of whether the motions are granted. Warner can also show the FBI letter contained false statements. Most obviously that the letter was authorized, drafted, and signed by FBI agent Langer. Yeah, damning if he can show it. IIED and defamation, the groupie video. Gore does not deny that she told others groupie was child illicit material. And evidence to be authenticated through deposition shows Wood was saying the same thing. The statement that groupie is child illicit material is unequivocally false. And it cites to CF Paterno, which says discovery defamation claim requires prima facie showing that the defendant's published statements contain provably false factual assertions. Yeah, you have to be able to, the statements that were made, you have to be able to come up with some kind of information that proves that what they were saying was false. Otherwise, if it's just an opinion, that's not something that would fall under defamation. The actress in the film confirmed she was not underage and was not abused. Nor were Wood and Gore merely repeating Warner's own words. And then citing to Wood's motion where it goes to Warner saying she was portraying a youngster in the film. It was not a pornographic film. Warner can show he suffered severe emotional distress caused by Woods and Gore's wrongful conduct, including this defamatory falsehood. Wood and Gore weaponized this falsehood to further their larger conspiracy to attack Warner. While Warner can show other harm, it is not required because false accusations of a crime are libelous per se. True. IIED, coercing victims to lie. Wood and Gore are incorrect to contend. So, okay, so I see this here in the chat. Helen, who says, I still don't understand the elements of IIED. So I do have a live stream that goes into depth into the IIED claims in this particular lawsuit. It's a long video. So the elements basically are Warner has to show that the Evan Rachel Wood and Illma Gore engaged in outrageous conduct that caused him, or that they did so with actual malice. Actual malice comes, it should be familiar after the Deputy Heard trial, that he suffered emotional distress as a result, severe emotional distress as a result. And finally, that the emotional distress was caused by that outrageous conduct. In other words, not by some other cause. So anyway. Okay. IIED, coercing victims to lie. So in other words, this is pointing to what Manson says outrageous conduct is coercing victims to lie is outrageous. Wood and Gore are incorrect to contend that Warner cannot identify any false statements in their communications to prospective quote unquote victims. At least one such victim has already admitted she was pressured to lie about supposed abuse by Warner. And Warner has denied the accusations that he abused anyone. That is sufficient. Citing to Tudor Saliba Corp v. Herrera, where it says denying anti-SLAPP discovery and defamation case where plaintiff did not deny making the allegedly false statements defendants attributed to him. Indeed. So in other words, he has denied. He has denied that he sorry guys, just one second. He has denied the accusations. So because of that, there is an issue here that could give rise to liability, in which case they could request discovery for this. Indeed, multiple accusers have confirmed they had no memory of abuse until attending Woods and Gore's groups years later, where they were supplied with the specific acts they would later claim Warner did to them. Further, Warner can show he suffered severe emotional distress caused by Woods and Gore's wrongful conduct, including their now successful campaign to coordinate and promulgate false accusations of abuse. Even Wood herself admitted the orchestrated attack had destroyed Warner. In sum, there is good cause to order the limited discovery requested by Warner so he may incorporate such discovery into his opposition to the special motions to strike and establish all of the elements of his prima facie case. Part C, the hearings on defendant's motions should be continued until a discovery needed to oppose the motions can be completed. Okay. This should be relatively quick. So basically, this is where he's saying, look, we need more time before this anti-SLAPP motion hearing happens because I need time to conduct this discovery. Which realistically, if the court is going to grant this motion to allow him to do limited discovery, they of course are going to be pushing the anti-SLAPP hearings back a little bit from September, because right now they're noticed for September. So if the court grants this motion, both parts will be granted. As a result of court's orders at the July 6, 2022 case management conference, Wood's motion is set for hearing on August 18th, 2022, and Gore's motion is set for hearing on September 13th, 2022. This leaves a mere 2 weeks to take the necessary discovery and incorporate such discovery into Warner's first opposition due August 5th, 2022. A brief continuance of these hearings is not only authorized, but also warranted to mitigate the prejudice Warner will suffer where he forced to submit oppositions without the benefit of completing the discovery he has requested. So with the 5 day difference between this filing and when this was refiled, my guess is this could be one portion that has been changed, because by the time they filed on the 25th, when they refiled this motion, this hearing was already pushed back once. So, but my guess is that this section is probably still in the motion, but that what they're requesting is actually for it to get pushed even further. Okay. The court has the authority pursuant to section 425.16G to continue the motions to allow completion of the authorized discovery. In Lafayette, the Court of Appeal stated that both that one, once the proper request is made, plaintiff must be given the reasonable opportunity to obtain that evidence through discovery before the motion to strike is adjudicated. And two, nothing in section 425.16G prevents the court from continuing the hearing to a later date so that the discovery it authorized can be completed where a reasonable exercise of judicial discretion dictates the necessity therefore. So, in other words, like I just said, if the court grants the ability to conduct some limited discovery, then then they're also going to be able to give extra time for the anti-SLAPP hearing, because they have to have time to actually do the discovery that they've now granted the ability to get. While the court could order the requested discovery be completed within a mere 2 weeks, under the circumstances, it is virtually impossible that Warner could complete several depositions, including out-of-state non-party witnesses pursuant to subpoena, during such a short time. For example, Agent Michelle Langer is a Florida-based federal agent. Warner's California deposition subpoena would need to be submitted to a Florida court, issued by the clerk of the Florida court, and served pursuant to Florida law. The deposition would need to be taken in accordance with Florida law, likely in Florida, And were Agent Langer to oppose the subpoena, a Florida court would have to resolve the issue. 100% true. These things can take an obscenely long time in comparison to the way that the rest of the world works. Litigation, it seems from the outside like it moves slowly, but when you're a lawyer actually working the case, it moves like you are constantly working on deadlines. Thus, in order to complete the discovery requested, plaintiff respectfully requests the court continue the August 18th and September 13th hearings on Woods and Gore's motions for a reasonable period of time to permit Warner to obtain and submit admissible evidence as part of his opposition to such motions. Conclusion. Based on the foregoing, Warner requests that the court enter an order pursuant to Code of Civil Procedure Section 425.16G, granting the discovery requested herein, specifically the depositions of 1. Third-party agent Michelle Langer, 2. Defendant Ashley Gore, aka Illma Gore, 3. Defendant Evan Rachel Wood, 4. Third-party Michelle Meyer, and 5. Third-party Catherine McGaffigan. To permit this discovery, Warner requests the court continue the August 18th and September 13th, 2022 hearings on Woods and Gore special motions to strike for a reasonable period of time so the depositions sought may be completed and the evidence obtained therefrom incorporated into Warner's opposition to Woods and Gore's motions. All right. So that is, and this is more from Appendix A. I'm not going to go into detail on all of these details because there's a few pages of this. And it is very particular. It is very specific. And I like the way that they organize this into a chart. They could have potentially organized this in terms of like paragraph form in the body of the motion. But I like the way that they did this because this makes it very clear to the judge exactly what they're talking about, exactly where this information comes from, where they need to apply it, the purpose for which they need to apply it, which element that they're talking about. You know, it makes it very, very, very clear. And I applaud their use of this particular chart in organizing it in this way, because when it comes to something about litigation is that sometimes what needs to happen is you need to make things as easy for the judge as possible. So whatever you can do to make it stupid simple for them, the better. Always going to be a better scenario when you have the judge looking at something that is going to be much more simplified. Okay. In other words, make it easy on the judge. Then they're more likely to find in your favor. So here's a declaration of Brian Warner. We're going to go through this next. But first, hang on. I need to change my banner here to Declaration of Brian Warner. All right. And before we do that, we're going to go through some more super chats here. Helen Who says, why not let Uncivil Law join you? He obviously wants to. Well, Uncivil Law is a great person and a great friend, but I did want to go through this much more, I don't know, in monologue fashion. I've been doing a lot of solo live streams lately, and sometimes it's great to have dialogue, but when we're going through these documents like this, I know myself and I know that I can get totally derailed when it comes to conversation with folks, that I can lose my spot, and that can make things confusing for people that just want to know what the document says. So, but I may have him come over at some point to talk about these at some point, if I can say things multiple times like that. All right. Aw, thanks, Kurt. I'm happy to hang in the chat and show support. I appreciate that. I really do. And Scott J, welcome to Bike Club. Happy to have you here as well. All right. So clearing those away. Okay. Now let's talk about this declaration of Brian Warner. What does he say? Am I blurry again, guys? I'm sorry if I am. But the document is not, however, right? Yeah, document is clear. That's what's most important. Okay. Declaration of Brian Warner. We're going to start with paragraph 2 here. I met Evan Rachel Wood in 2006, and we had a romantic relationship until approximately 2010. During that time, we were engaged to be married and carried on a loving and consensual relationship. Eventually, like many couples, we broke up. I never abused, assaulted, raped, or threatened Wood or her family, as she has since contended. Her accusations against me of abuse, assault, rape, threats, and the like are unequivocally false. I understand that on or around April 1st, 2021, Wood posted to Instagram that I was her abuser, and shortly thereafter, a number of other women simultaneously emerged with false public accusations against me of abuse, assault, rape, threats, trafficking, and the like. These women include Ashley Morgan Smithline, Ashley Walters, Jane Doe, and Esme Bianco. To the extent I had relationships with these women, those relationships were consensual. I never abused, assaulted, raped, threatened, or trafficked any of these women as they contend. Their accusations against me of abuse, assault, rape, threats, and the like were unequivocally false. Wood and her one-time girlfriend, Illma Gore, have also accused me of abusing and or threatening to abuse children. I am not a child abuser and have never abused or threatened to abuse any child. My film Groupie was not quote unquote child illicit material. It was a professional art horror film I created and wrote, and which was filmed by director Joseph Cultus. The actress Paula Weiss was over 21, and there was no sex in the film. Prior to filming, Weiss and I went through film's concept, plot, and some high-level dialogue. When I screened Groupie for Wood in about 2009, I told her the actress was Weiss, an ex-girlfriend. After watching the film, Wood told me she was very impressed with it. Her only criticism was that she, Wood, had not been able to star in the film. I understand that Wood and Gore continue to promulgate the falsehood that I am a child abuser and that Groupie is child illicit material, as somehow lending credence to Wood's false accusations and enhancing their perceived influence with prospective accusers. For example, in the 1990s, I was introduced to and became friendly with Catherine McGaffigan and her friends Jeanette Pollard or is it Pollard? And Allison Duffy. McGaffigan, Pollard, and Duffy appeared in my tour documentary Dead to the World and have been credited as quote unquote cast of that film on the website IMDb. I understand from documents given to me by McGaffigan comprising conversations between her and Gore that in September 2020, Gore attempted to recruit McGaffigan for a quote unquote group of survivors of violence with similar experiences, specifically quote unquote abuse suffered from other teenagers, allegedly by me. In support of that proposition, Gore stated Groupie was not released because the girl was underage. The content horrifies people, and the FBI got involved. None of McGaffigan, Pollard, or Duffy appeared in Groupie, and I never abused or threatened to abuse McGaffigan, Pollard, or Duffy. I understand further that on March 3rd, 2022, Gore posted to Twitter calling me a rapist pedophile, and on approximately March 15th, 2022, Wood appeared on the Trevor Noah show stating that there have been allegations and stories that have come out on the internet that involve minors, and you got to draw the line somewhere. And with children, I have to draw the line there. And I don't believe that he will stop until he is stopped. And there's the footnote here which cites to a particular video. I will have to watch that at another time. Again, I am not a child abuser and have never abused or threatened to abuse any child, and I never would. I have suffered severe emotional distress as a result of Wood's and Gore's conduct as alleged in my complaint. I am not a rapist or abuser, but many people now apparently think that I am. The individual acts alleged in my complaint were not isolated events, but rather part of an intertwined and long-running conspiracy and course of conduct to cast me publicly and falsely as a rapist and abuser. This conduct included not only pressuring and causing women to emerge with coordinated false allegations of rape and abuse, but also other acts used to promulgate and amplify those public falsehoods. For nearly a decade or more, none of these women accused me of rape or abuse, as no rape or abuse happened. I have been the target of a fake letter purportedly from a real FBI agent whom I understand has told my counsel that she did not draft, sign, or authorize the letter and had never investigated me, any matter related to me, or any matter related to Wood. In addition, I have been defamed, impersonated, hacked, and swatted by Wood and or Gore. After Wood's and others' lies about me became public, the media firestorm was exacerbated when Gore falsely reported that there was an emergency at my home, causing low-flying police helicopters, spotlights, squad cars, and armed officers to be deployed to my home for hours on multiple occasions. I have never met or spoken to Gore, I think is what it's supposed to say. Her report of an emergency was false. Members of the press appeared to be some of the first on the scene, and this chaos was reported as somehow being connected with the false allegations against me. Photos of my house and my address were published online and in newspapers, and paparazzi and media camped outside for weeks. My wife and I were forced to move out and sell our home. Holy crap. That's a lot. I mean, that's a lot if you're forced to move and sell your home. After being falsely portrayed as a rapist, abuser, and child pornography, illicit material provider, my career as a musician and recording artist has suffered, including because I have been unable to tour and was dropped by my record label and agency. My film and television career has suffered, including because I was pulled from 2 television shows, one of which was a recurring role. My art career has suffered, including because the release of my book and art shows have been indefinitely postponed, and my paintings have been devalued. I have received countless death threats online. I have been excluded from countless social and business gatherings, and I have constantly felt anxious, distraught, depressed, worried, frantic, sleepless, and fearful for my and my wife's physical safety. So here he has definitely alleged that he has been harmed. Because of the IIED claims, right? Because of the allegations and whatnot that he says have come out. Um, yeah, there's if all of that is true, that would tend towards showing damages. Okay, and then that's it. That is it for this one now. Okay. Now, of course, that is the declaration of Brian Warner. That's a self-serving document because he's one of the parties here. So we would expect that to basically look exactly like that. Nothing in there really surprises me. It just reinforces what he says, what he alleges in the complaint. So let's see what we have in terms of the other declarations. If I can share this one. Briton Gore. And I know that this one is a little bit controversial. I did see some stuff on Twitter about Briton Gore. There's another I think a temporary restraining order that she was trying to get against Illma Gore. I don't know the specifics around that. But there's a possibility that she may have she is having aspersions cast on her. Whether or not those are true, I have no idea. But let's go through her declaration nonetheless. To see what she has to say. Declaration of Briton Gore. Okay, so starting with paragraph 2. Ashley Gore, aka Illma Gore, is my identical twin sister. Until approximately June 2021, I was living in Australia. In 2019 and 2020, I regularly kept in touch with Illma. She told me that she was dating actress Evan Rachel Wood. In or around April 2021, Illma traveled to Australia and stayed with me, my daughters, and my roommate. Illma told me the purpose of her visit was to help me move to the United States in 2021. We had discussed me wanting to rejoin our family members who lived in the United States. During this trip to Australia, I witnessed Illma using an iPad Pro. Illma told me she borrowed the iPad Pro from our cousin Madeline Dins, who lives in the United States, because Illma's own iPad had been damaged by Wood's son, Jack. She told me her broken iPad was in the United States. In or around April to May 2021, I was sitting next to Illma in the sunroom of my house while she was on a call with Wood over the speakerphone. Illma told me it was Wood on the phone. During this call, Wood said there was something wrong with the FBI letter and that she needed Illma to send her a copy. This call was tense and Illma appeared unnerved. Illma was using the iPad Pro. I witnessed Illma use the Procreate application, a graphics editing tool I was familiar with, to transfer a signature from one document onto what appeared to be a letter from a federal law enforcement agent. Watching this was alarming, so I asked Illma what she was doing. She said letter was from the Federal Bureau of Investigation and it was okay because she said, I know the agent and have her number. When Illma was finished working on the letter, I watched her send it back to Wood. Okay. If this is true, incredibly damning. Incredibly damning. Now, whether or not Briton is a credible witness will be another question, but that's a jury question. We have her at this point saying, I saw her transferring the signature and she said it was okay. In June 2021, my daughter and I moved to the United States from Australia. We first stayed in Oregon with Dintz's mother. In or around July 2021, we moved into a house in Watsonville, California with Dintz. Illma previously told me in about April to May 2021 that she wanted to move in with me and Dintz, although Illma was living in Los Angeles. In or around July 2021, Illma began staying with us in Watsonville after she told me she had a conflict with her roommate in Los Angeles and was moving out. Around this time, August to September 2021, a number of Illma's items and furniture were delivered to the house by truck. I first saw the broken iPad while Illma was staying with us in Watsonville. Illma gave me the iPad and told me it was a gift for me and my daughters. The screen was cracked and it did not power on. I'm only chuckling because it's just like, if that's true, like that's a crappy gift. Thanks for this iPad that doesn't work. I put the broken iPad away for safekeeping until I could afford to or figure out how to fix it. During this time, I observed Illma continuing to use Dintz's iPad Pro. In or around September 2021, living with Illma became intolerable. Illma vacated the house, saying that she was going on a work trip to Florida. She did not come back. Illma left behind various items, furniture, and boxes at the house. She took Dintz's iPad Pro with her. She did not take the broken iPad that she gifted to me and my daughters. When Illma left, there was no doubt in my mind that the broken iPad belonged to me. So what she's saying here is, I didn't steal this iPad. She gave it to me. She left it behind with no intent to return for it. In or around October to November 2021, I attempted to get the broken iPad running. I did not get the screen fixed because it was too expensive. However, I plugged the broken iPad into a weaker power source, not the wall jack, which I thought may help it get powered up. It worked, and the broken iPad powered up. Over the years, Illma shared her iCloud credentials with me so that I could use her account and Apple devices. I opened the iPad with these credentials once it was powered up so I could use it. What I saw on the broken iPad horrified me. Among other things, I saw emails and draft emails that were purportedly written and or sent by me, which I never drafted, authorized, or sent, and social media posts and draft posts purportedly written by me, which I never drafted, authorized, or posted. I also saw a number of items on the broken iPad relating to Wood, the Phoenix Act, and Brian Warner, professionally known as Marilyn Manson, who I knew was Wood's ex-significant other. One item I saw on the broken iPad was a screenshot of a text conversation on the Signal app between Wood and Illma. A true and correct copy of that screenshot is attached as Exhibit A. The screenshot was dated December 20th, 2020. The conversation dated Sunday, November 22nd. November 22nd fell on a Sunday in 2020, was between someone named Alabama on one hand and someone who said that 424-489-1211 is my new number on the other hand. I know this is Illma's phone number because I used the same number to call her. As described further below, I understand that Alabama is Wood because Illma told me she referred to Wood as Alabama, and I witnessed and took part in conversations over the Signal app in which Wood used the nickname Alabama. In this conversation, Wood stated, "Here is the letter. To whom it may concern, please be advised that Miss Evan Rachel Wood is one of the primary witnesses in connection with an impending criminal prosecution in Los Angeles involving an international and well-known public figure. We have advised Miss Wood that in our opinion, it is in her and her family's best interest to not be in Los Angeles at the time of this individual's arrest and the criminal proceedings. The safety of Miss Wood, her son, Jack, as well as the other victims and their families are of utmost concern during this time. What do you think?" Illma responded, "It's good. I don't know about the letter stating the arrest before it happens." So this was when I was going through the complaint over a live stream. I did say, I was like, I remember seeing that text exchange that was included in the complaint as a screenshot in the body of the complaint. And I remember saying, this is interesting, but I wonder how Marilyn Manson got access to these text messages because it seems like this is between Ashley Gore and Evan Rachel Wood. How would he have access to their one-to-one conversation? And so this answers that. Whether or not it's true is something that would be poked and prodded by the opposing side through the discovery process, and then if it goes to trial while she's on the witness stand. So whether or not that's believable would be up to a jury. However, she has laid a trail of breadcrumbs to explain how those text messages got into eventually Marilyn Manson's hands. Now we understand that. Another item I saw on the broken iPad was an image of an undated letter purportedly written and signed by quote unquote Michelle Langer of the quote unquote Federal Violent Crimes Department. A true and correct copy of that screenshot is attached as Exhibit B. This letter stated, "To whom it may concern, please be advised that Miss Evan Rachel Wood is a key witness in connection to a criminal investigation in Los Angeles, California, involving an international and well-known public figure. The safety of Miss Wood, her family, other victims, and of their families are of the utmost concern during this time. Contact for more information regarding the safety of victims of human and sex trafficking crimes." This letter looked very similar to the one I witnessed Illma work on in or around April to May 2021, when I saw her transfer a signature from one document to another and send the finished letter to Wood. Another item I saw on the broken iPad was an image of a document titled Federal Bureau of Investigation Receipt for Property, dated December 18th, 2020. A true and correct copy of that screenshot is attached as Exhibit C. At the bottom of the document, next to received from is Illma's name and a signature, and next to received by is the name Elizabeth Farrell and a signature. This appeared to be the same document and the same signature for Farrell that I saw Illma use in or around April to May 2021 to alter the letter she sent to Wood. This image also reminded me of a conversation I had with Illma in approximately December 2020, in which she told me she was investigating Warner. The FBI was involved. The investigation, quote unquote, was getting serious, quote unquote, and accordingly, she expected to be very busy. Another thing I saw on the broken iPad were at least two images of a checklist. One checklist was blank and the others were filled in. A true and correct copy of two such images are attached as Exhibit D. There are so many exhibits to this. Another series of items I saw on the broken iPad were pictures of emails and text messages from Ashley Walters that contained email addresses, social media logins, passwords, addresses, social security numbers, and other personal information about Warner. Around the same time, I also looked through the items Illma had left in the garage upon leaving for Florida, including unorganized and or crumpled stacks of paper and other trash. One item I saw in these discarded materials was a piece of paper covered with what appeared to be my sister Illma's handwriting, which I recognized. Okay, and that is Exhibit E. Another item I saw in these discarded materials was a notebook filled with what appeared to be my sister Illma's handwriting, which I recognized. And that's Exhibit F. In or around early November 2021, I participated in a phone call over the Signal app with Wood, Dintz, and Dintz's mother. We used Dintz's phone. I observed that Wood's Signal name was Alabama. I recognized her voice, and she identified herself as Wood. Wood wanted to discuss what had happened while Illma was living at our house. According to Wood, Gore said, I had died 3 months prior. I said I was not dead. I'm not dead yet, says the Monty Python sketch. The conversation moved to what I saw on the broken iPad and in Illma's discarded items. I told Wood that I had seen a letter supposedly written about her by an FBI agent. And earlier that year, I witnessed Illma doctor the same or a similar letter. In other words, that I knew the letter was fake. Wood's response shocked me. She said the letter was so important to her work against Warner and told me to, quote, think of what would happen, unquote, to her and the quote unquote victims if this ever got out to the media. I offered to send Wood or her attorneys his materials, but she declined. That's not a good response. That kind of a response from Evan Rachel would indicate that she knows about all of that. She knows about the falsities. She knows about the fact that that all of these things are suggesting that those documents are false or fake, and that she's saying, think about what would happen to me. Think about what would happen to these other women who have accused Brian Warner of all of these things. So regardless of whether or not Briton Gore has certain issues with her credibility at this point, that's a jury issue, which is, in other words, a muddy middle issue. There's a lot here for purposes of the anti-SLAPP motion to show that Marilyn Manson has the ability to put on a case. Okay, let's look at some of these exhibits here. Okay, so this is the screenshot of the text messages between Alabama and the phone number that is supposed to be Illma Gore's. Yep, and we saw this in the complaint. You can see that and now in the complaint we saw a black and white version. And so this makes it much more clear. This version of it makes it much more clear that you can see the cracked glass on here. So it's actually probably not a screenshot, but it looks like it's a photo of the iPad from the screen. Okay, so there's that. Exhibit B, which she says was also on the iPad. Yep, you can see the cracked glass here as well, which this looks like the purported FBI letter, which is the only thing that has been redacted here is the phone number here of Michelle Langer, which has been indicated on the letter. For one reason or another, that one has been redacted. Okay, and that's a letter that says, to whom it may concern, please be advised that Miss Evan Rachel Wood is a key witness in connection to a criminal investigation in Los Angeles, California, involving an international and well-known public figure. The safety of Miss Wood, her family, other victims, and of their families are of the utmost concern during this time. Okay, contact for more information regarding the safety of victims, human and sex trafficking crimes. Okay, so that's Exhibit B. Exhibit C then is... What is this? Okay, it says at the top, United States Department of Justice, Federal Bureau of Investigation, receipt for property. Okay, it's kind of hard to make this out just because of the blurriness of the screen. Okay, but she identified that. Exhibit D. This is, it looks like the checklist that we saw that was connected to or attached to the complaint before. So we've seen this as well. It says name, contact, willing to testify. Yes, no, it's complicated. Were they a sexual partner, a spouse, a staff and or band member? And then it goes through all of it's like a menu of items almost for people to check as to what they encountered with Brian Warner, aka Marilyn Manson, during their encounter with him. And here is a photo of a paper version that is filled out by someone named Gabriella. It says they were a spouse. Well, that's interesting. Okay. I don't know how many times Marilyn Manson has been married, so I wouldn't know if this would be possible or not. But that's interesting. Sexual partner and spouse have been checked off on that one. In Manson case, it says Gabriella is one of the accusers, but I don't know if were they married though? That's another question. Exhibit E, we have also seen this. This was also attached to the complaint. We see writing that is, it looks like basically a script has been edited through various versions indicated by different colors and handwriting. Interesting. Exhibit F. Now this looks new. Oh, except for the Phoenix Act to protect to make money doing that. Okay, but this is interesting because you can see almost the full page here. Goal. Why? Because I am something. My plan is good and my art is unique. You can sell for millions with strategy. This is proven. Damien Hirst, Warhol, Go. Van Gogh is, I think, maybe what she meant. Ultimately, to make more art, personal, create a brand. You are unique, interesting, and have weird interest in perspectives. Stand by them. Admit when you're wrong. Paint. You are talented. To excel. Phoenix Act. To protect. To make money. Doing that. Interesting. All right. And this appears to be the end of this particular exhibit and this declaration. Okay. So like I said, I anticipate just because of the things that have come out recently that have been fought over on Twitter about a TRO issue between her and Illma Gore, it sounds like there's a side issue that could potentially come in for her credibility, possibly, maybe. But we'll see. I mean, I don't have a full grasp on what that issue actually is, however. So I don't feel comfortable like really saying much more on that aside from basically that I would anticipate that there could be some kind of an issue that comes up with her. But if she proves to be a credible, let me say it like this, if Briton Gore does prove to be a credible witness, her testimony could be very, very, very damning to both Illma Gore and to Evan Rachel Wood for the IIED claims, particularly because she doesn't really talk about the groupie video. She didn't really seem to see anything about the groupie video, but it seems like she did see stuff about the FBI letter, stuff about the checklist with other women, but it seems like she wasn't privy to the conversations that Illma Gore and Evan Rachel Wood had with the other women that are also accusers. So partial information on that point, but really it seems like Briton Gore is very important. Her testimony is very important for the FBI letter issue. Okay, let's move on to Howard E. King. All right. Okay. All righty. Howard E. King. Let me bring this up a little bit more, zoom in a little bit. Yeah, camera is probably very, very blurry. Okay. So, and this is a good question from Julia543. Can you kind of summarize what the document said? Sure. Basically, what Briton Gore said was that she witnessed, by being in person with Illma Gore, she witnessed a phone conversation between Illma Gore and Evan Rachel Wood talking about the editing of the FBI letter. And then she says that she saw Illma Gore actually transfer a signature from one document of an FBI agent from one document to another. And then she says that she came across text messages between Illma Gore and Evan Rachel Wood about the FBI letter, about the actual drafting of it, basically saying, like, what do you think about this wording? All of those would tend to prove, assuming that it's correct, all of that information would tend to prove that they were in fact fraudulently putting forward a narrative about this FBI investigation. And if that is used, if that FBI letter was actually used to try to recruit other women and to try to pressure other women into participation into a scheme, as Manson alleges here, then that would that would be very useful for that particular claim for IAED. I hope that explains it for you. Okay. And to answer Ryan Blackhawk's question here, does the agent know that her signature was used on the document? So Agent Michelle Langer is one person that we will be getting to a declaration from one of the lawyers who says that they talked to Michelle Langer, who says that she's now aware that her signature was used, but that she never authorized that. She didn't have anything to do with anything. Okay. Declaration of Howard E. King. I am an attorney licensed to practice law in the state of California and serve as counsel for Brian Warner, professionally known as Marilyn Manson, in the above captioned action. The following facts are within my personal knowledge, and if called as a witness herein, I can and will competently testify thereto. I instructed my office to pull certain publicly available records from the Tennessee State Court case captioned Evan Rachel Wood v. Andrew J. Matvin Bell, docket number 21D-284, pending the Third Circuit Court for Davidson County, Tennessee at Nashville. Attached hereto as Exhibit A are true and correct copies of excerpts of those records, including sworn declarations and attachments submitted by both Wood and Bell. These publicly available sworn documents state that on the morning of December 22nd, 2020, Wood sent Bell an email stating, "I have been advised that both Jack and my safety is at risk and that it is in our best interest to remain in Nashville. I will forward you my contact at the FBI, and you should feel free to call with whatever questions you have." These publicly available documents further state that Bell submitted a sworn declaration under oath stating, "I received a letter from Evan on December 23rd, 2020, supposedly from law enforcement personnel connected with the investigation. The letter was sent to me through the messaging app called Signal. I have attached a true and correct copy of the version I was able to save from the app as Exhibit E. This version shows Evan's name at the top of the post. When I first received the message, another person's name was at the top of the post, Illma Gore. Evan deleted that post. The letter was not on any kind of department letterhead and was supposedly from a woman named Michelle Langer of the Federal Violent Crimes Department. I Googled but found no such department or woman. I called the number for Michelle Langer on the letter for 2 days. This person gave me another number on which I called and left a voicemail. I never heard back. So I will say that the letter to me looks extremely, extremely suspect from having read it. I don't know exactly where this letter came from, whether it came from Evan Rachel Wood and Illma Gore. This seems to be this is 100% what is suggested, not just suggested, but what is alleged by Briton Gore and others, right? But I will say that if in fact it is the case that Evan Rachel Wood and Illma Gore actually forged a letter from the FBI, regardless of whether it's Evan Rachel Wood and Illma Gore, if anyone forged this letter, if you're gonna forge a letter, I'm not gonna try to help people get away with crimes or whatever, but it's strange to me that someone wouldn't at least Google it to see if that actually exists, instead of just like coming up with it and being like, oh, no one will ever double check us, even though we're in an adversarial process. And like the other side has every interest in trying to make me prove every single point. Anyway. Okay. I Googled but found no such department or woman. I called the number for Michelle Langer on the letter for 2 days. This person gave me another number on which I called and left a voicemail. I never heard back. These publicly available documents further state that attached to Bell's sworn declarations are emails between Bell and Wood, in which Wood told Bell on December 23rd, 2020, in response to Bell's statement that it appears I have been calling the incorrect number for 2 days, that if the number Michelle put on her official letter isn't reaching her, then I would assume the other number is also correct. I also signaled you another number. Bell responded, the number beneath Michelle's signature on the letter you sent belongs to a different Michelle. Wood responded, I see. Not sure what happened then. You'll have to ask Michelle when you reach her. These publicly available documents further state that attached to Bell's and Wood's sworn declarations are copies of a letter purportedly written and signed by FBI agent Michelle Langer. On March 2nd, 2022, Warner filed a complaint in the above caption action. On or about March 2nd, 2022, I instructed my office to download and print any tweets posted from the verified Twitter account of Illma Gore, at Illma Gore, a true and correct copy of 3 such tweets that were collected at my direction on or around March 3rd, 2022 is attached here too as Exhibit B. On April 28th, I would say I would say that generally speaking, the practice should be try to get those tweets before you file, because before they have notice that they've got a lawsuit on their hands. Usually that's helpful, because then you're even more likely to get all of the tweets that you need. But anyway, March 2nd is when you file. They get served later, so they probably had enough time anyway before she had notice. Anyway, regardless. All right, so they attached it as Exhibit B. I will be very interested to see those tweets. What do those say? On April 28th, 2022, Wood filed a special motion to strike portions of the complaint. On May 24th, 2022, Gore filed a similar special motion to strike following a stipulated extension. Wood and Gore noticed hearings on their motions for December 13th, 2022 and January 31st, 2023, respectively. Based on these dates, we understood and relied upon the fact Warner would have several months to 1, collect and organize the admissible evidence needed to defeat defendants' motions, and 2, where additional evidence was needed but not available to Warner, such as evidence regarding Wood's and Gore's intent, to file a notice motion seeking an order to lift the automatic discovery stay. Prior to the July 6, 2022 case management conference, my office met and conferred with counsel for Wood. Counsel for Wood was informed Warner would be seeking to lift the discovery stay. In other words, before July 6, 2022, before this hearing was moved up from December, January to August, September, we were talking with Evan Rachel Wood, with her lawyer, about getting discovery. So we weren't just sitting on our asses. We were having conversations with them about this. Is what they're starting to lay out here. The topic of advancing the motion hearing notice for December 22, 2022 was not discussed. In other words, When they talked about potential discovery, Evan Rachel Wood's attorneys never said, hey, we're planning on moving the hearing up. We're planning on asking to move the hearing up. In Wood's CMC statement, the case management conference statement, which is a basic form that both sides have to fill out to basically say what issues they have coming up, what issues they have that they want to have resolved by the court, et cetera, et cetera. She did not ask for the hearing to be advanced. Prior to the July 6, 2022 case management conference, my office met and conferred with counsel for Gore. Counsel for Gore was informed Warner would be seeking to lift the discovery stay. Same thing. The topic of advancing the motion hearing noticed for January 2023 was not discussed. In Gore's CMC statement, she did not ask for the hearing to be advanced. So same thing. At the July 6, 2022 case management conference, the court ordered sua sponte, on their own motion, at the request of no one, that Wood's hearing be advanced to August 18th, 2022, and Gore's to September 13th, 2022, compressing the time Warner had to oppose the motions to just a matter of weeks, given that the first opposition would be due August 5th, 2022, under Code of Civil Procedure Section 1005B. The court advised Warner that to the extent he sought discovery in advance of the new August 5th opposition deadline, he would have to move. He moved for such an order ex parte. I discussed ex parte hearings earlier. So if you missed that, you've got to go back to earlier in this live stream. Warner will suffer immediate and irreparable harm if the request for limited discovery is not heard on shortened time and the hearings not continued, including because if Warner and the court were to comply with the regular notice requirements of Code of Civil Procedure Section 1005B, a hearing on regular notice could not be held until after his opposition to the first motion to strike was already due, and Warner would be deprived of specific admissible facts within defendants and certain non-party witnesses' control needed to establish his prima facie case and defeat the motions to strike. In other words, so he says the attorney here is saying that if the court grants the motion to conduct limited discovery, but they don't agree to move back the hearing date, they're not giving enough time for them to conduct discovery. And this is because when a request is made, generally speaking, let's say so August 18th is the date of the hearing for this particular motion. Let's say on that date, the court says, okay, you can do discovery. Even if they just that day notice discovery requests, they send discovery requests or serve discovery requests on the other side, I should say, they have to give 30 days in order for them to respond. And then let's say they respond and Illma Gore's and Evan Rachel Wood's responses are, if it's written discovery as an example, if those responses are all objections, they don't give anything substantive, then they have to duke it out. They've got to fight back and forth and say, no, you didn't fully respond to this request. You didn't fully respond to that request. And that eats up time. If in the meanwhile, you have this hearing that is like right on the cusp of like just after this, these responses would be sent back, all Evan Rachel Wood and Illma Gore would have to do is just like run the clock by sending objection responses with nothing substantive. So this is why they would have to give this cushion of time, this space of time, in order for that to be in the interest of justice, basically. My office attempted, but was unable to obtain a declaration from non-party witness Michelle Meyer. Counsel for Meyer stated she would be willing and able to comply with a court order or subpoena, and he would accept service on her behalf. Attached here to his Exhibit C are true and correct copies of text and or emails messages between Gore and Meyer that Warner seeks to have authenticated through the limited discovery requested. I understand Meyer may be living outside of California. My office attempted, but was unable to obtain a declaration from third-party Catherine McGaffigan. Attached here to is Exhibit D are true and correct copies of text and or emails messages between Gore and McGaffigan that Warner seeks to have authenticated through the limited discovery requested. I understand McGaffigan may be living outside of California. My office contacted counsel for Wood asking whether she would sit for a deposition before August 5th, 2022, and what days she would be available. We also asked whether Wood would oppose Warner's request for a continuance of the hearing. Wood responded but did not provide any dates and said she would oppose any discovery, continuance, and ex parte application. A true and correct copy of those emails are attached here too as Exhibit E. And that's to be expected. This is an adversarial process after all, and so her Wood's attorneys are not about to just say, "Hey, yeah, we'll have you. We'll allow you to talk to our client when they're not compelled to do so." Right? We'll just volunteer that. No. My office contacted counsel for Gore asking whether she would sit for a deposition before August 5th, 2022, and what day she would be available. Can you guess what the response was? Probably the same. We also asked whether Gore would oppose Warner's request for a continuance of the hearing. Gore responded but did not provide any dates and said she would oppose any discovery, continuance, and ex parte application. Yep, that's about as I expected. On July 20th, 2022, at approximately 9:30 a.m., my office gave notice of the ex parte application, motion for limited discovery, request for continuance, and July 22nd ex parte hearing date and time. Okay, and then basically this is just going through saying that they gave notice of that ex parte hearing. Okay. Exhibit A. Notice of filing California pleading. So this is from the matter between Wood and Bell. Okay. Declaration of Evan Rachel Wood in there. And let me see here. Exhibit 1, and there's the use of the letter of the proposed FBI letter. And then it goes to Exhibit 3 of this. It's like sub Exhibit 3. This is a letter from Lenore Pink to James Bell. Dear Jamie, I'm writing this email to you to let you know that Jack and I will be staying in Nashville for the immediate future. As you will soon find out, I am a material witness in a high-profile criminal investigation, which is likely to be public in the near future. I have been advised that both Jack and my safety is at risk and that it is in our best interest to remain in Nashville. I will forward to you my contact at the FBI, and you should feel free to call with whatever questions you have. I know how difficult this is for you to be away from Jack for an extended period of time. I will do whatever I can to accommodate you should you want to come here to visit him whenever you want. I, of course, will facilitate FaceTime with Jack on a frequent basis. I'm available to answer any questions you may have. Thank you for your understanding during this very difficult time. Shine on. So it looks like this is Lenore Pink is actually Evan Rachel Wood. James Bell is Jamie Bell. Man, to get an email like that, like 2-3 days before Christmas. Like, I wonder if this was his first notice that his son was moving across the country, or did they have notice like otherwise beforehand? Because that would suck to find that out like 2 or 3 days before Christmas, like I said. Okay. All right. Wait, this is row. Okay. Okay. So declaration of petitioner. So this is more. This is okay. This is a declaration that was filed by Jamie Bell, referenced earlier. I'm not going to go through all of this because this is a very long, long document here. Okay. All righty. Declaration of petitioner. Okay, and then Exhibit D. Okay, there's that same email again. Exhibit E, that purported FBI letter. Exhibit F. Okay. Oh, wait a minute. Is this another email instead? No, that's the same one. Sorry, guys. Sorry. Okay, Exhibit F here. Jamie, thank you for your email. It's from January 10th, 2021. I too want to resolve things during these very tumultuous times. Unfortunately, the filing of the criminal case is taking longer than anticipated, and I remain afraid for our safety. The solution is not having Jack stay with you because he remains in danger in LA, where the perpetrators reside not far from your house. I am one of the many victims receiving death threats. These threats extend to our loved ones. Last night, I was made aware of more death threats against me, which I am reporting to the police. I believe the best chance for success is to mediate this with a private judge and our attorneys. I would ask that you have your attorneys contact my attorneys, Samantha F. Spector and Lisa Helfand-Meyer, to arrange for a mediation in the near future. If you do not have counsel or decide not to hire an attorney, then we can still schedule a date with a private judge and my attorneys. I look forward to working this out. Is it just me? Is it just me or does it feel very formal? If you're talking to an ex, are you this formal? I don't know. Is she normally this formal with the way that she talks to people that are very familiar to her? I don't know. And then we've got an email from Lisa Hacker at hackerfamilyresolution.com to Jamie Bell, Evan Bell Wood. Hello, Jamie and Evan. Just following up to see if you would like to schedule a time to speak with Lisa tonight. She is in session until 7 p.m., but happy to speak afterwards. If tomorrow morning works better, she is available as early as needed. Thank you, Melissa. So this is somebody who is probably her assistant or something along those lines. This is also December 22nd, 2020. Oh, same day that she emailed him about that. Okay. And then Jamie Bell responds, same day. Thanks, Melissa. I'm available tonight and tomorrow and can make both work. Thank you, Jamie. Okay. And then on December 22nd, from Jamie responding back to Evan Rachel Wood saying, hi, it's important to me that we connect with Lisa Hacker to discuss how things will work moving forward and establish a plan of action. She is available this evening and is willing to speak with us. I'm reaching out to her office on our behalf to set it up. Okay. And then on the 24th, from James Bell to Lenore Pink, who I guess is Evan Rachel Wood. It says, I have left word with Michelle and am awaiting her response. I have also left word with Amanda and Guillermo. I will see if Lisa is available to jump on a phone call, although I'm sure it's very tricky now as we're so close to the holiday. We may have lost her. Yeah, who's working on Christmas Eve? Okay, and then James writes to Evan on December 29th, 2020, saying, Evan, I hope you guys enjoyed your Christmas. It was sad for me not having him here as I had expected. Oh, so he did not seem to have much notice, it seems like. As we so far have successfully alternated the holiday period every year with him, it really is something I cherish and look forward to, and having the plan upended and so suddenly changed was very difficult. I'm reaching out once again to ask if you will get on the phone with Lisa Hacker and I to discuss the schedule in terms of Jack's care. It's important to me that we quickly come up with a plan for his return to Los Angeles and to my care, as it's now been several weeks since I've seen him. Obviously, I'm factoring in the busy holiday travel period, and to be on the safe side, we should likely wait for it to die down a little. More people are traveling during this pandemic than anyone anticipated, and reducing his risk of exposure should remain our top priority. I will be reaching out to Lisa's office to see if they are back in operation after the holiday, and if there is a time that works for us both in the coming days. I sincerely hope you're agreeable this time. Jamie. To his credit, I mean, he does seem to be very very civil during this, and that's not always the case during these kind of custody matters. Okay, so here is Exhibit B, the Illma Gore tweets. There's 3 tweets that they identified in the declaration. Okay. From April 2012. Oh, sorry. Joined April 2012. Never mind. What's the date on this tweet? Let's see here. Can I zoom out further? Possibly. No, maybe not. No. Okay. Oh, sorry. This is just her profile. Okay. Artist, 2D, 3D designer, junior software developer. For inquiries and complaints, please email foundation.app/Illma Gore. Okay. Oh, sorry. These are the tweets. It's because it's so big on my screen. Okay. From 3 hours ago. Again, I can't see the date. This is a little bit frustrating for me. Okay. It says 3 hours prior. I guess you go from bottom to up, right? Bring it the F on, you rapist, pedophile, mother effer, she says. And I'm the one that censored that, not her. Before publishing images, be aware that photos and images from my hard drives have been registered with the U.S. Copyright Office. This documentation names me as the rightful copyright owner. I have not, nor will give permission to use them. We can have a conversation with Illma Gore about copyright and how some images are copyrightable and others are not. It depends on what exactly it is that she's talking about. If she's talking about claiming copyright protection for screenshots of conversations, for example, between her and Evan Rachel Wood by text, probably not copyrightable. Most likely not. And also, even if something is copyrightable, there is the possibility of using them in litigation because otherwise you wouldn't possibly be able to have copyright litigation. Okay. So I've got some issues with this particular tweet. Obviously, my art and my life have long been magnets for controversy, but these recent claims about me are horrible distortions of reality. Okay. Oh, sorry. Based on the declaration, these were taken on March 2nd and March 3rd, I think. March 2nd, I think. Okay, Exhibit C. Illma Gore. This looks like a text message between her and someone else. Let's see. Hey, this is to contact you. This is the contact to the investigation for you to leave a message. She will direct you to the right person. And the contact information, it says Michelle. She probably won't answer, but leave a message. Hope you haven't been spammed too much lately. Thanks. I will call her tomorrow and leave a something. I just received 2 voicemails on my cell just now looking for Michelle Langer. Sean Hawley called saying she represents Evan and Jamie Bell called saying he's the father of Jack Bell. I haven't returned the call to tell them they have the wrong person. Do you want me to call them or can you and Evan sort it out on your end? Don't respond. I'll have it fixed immediately. Sorry for that. Someone got the numbers mixed up. Okay. So I'm sorry. I'm confused. This text message right here, these are between. Okay. So same date, it looks like probably. And then no, not the same date. October 14th, 2020. The second screen is from December 22nd, 2020. Okay. So December 22nd, 2020 was the date that they gave Jamie Bell the contact information, the FBI letter, from what it looks like via email. So it seems like he would have called immediately based on what it says here. And now, okay, but then who was this one to? I mean, because it looks like Illma Gore. Usually the person in green on WhatsApp is a person whose like home screen is in there. So who's I'm a little bit confused as to who these messages are between. This looks like this is the other Michelle and Illma Gore, but this is between Illma Gore and someone about the other Michelle. However, okay. I'm a little bit confused here on this. We'll move on for now. Exhibit D. Okay, this is from Illma Gore. It looks like on Instagram, September 30th, 2020. Hey, this is random and completely uncalled for. But my name is Illma. I'm a friend of Evan Rachel Wood, and I help run the Phoenix Act. I just wanted to reach out and say there's a group of survivors of violence here with similar experiences. And if for whatever reason you ever wanted to talk about what I do for Phoenix or even just touch base, to be connected to everyone else at the very least, know that you can at any point. Best, Illma. Okay, sorry, what date was that? September 30th, and then October 3rd, 2020. I'll be really candid with you. I run Phoenix alongside Evan Rachel Wood. We ran into lots of teenagers being groomed by adults in the music industry. Evan, ex-staff, and others speak about the groupie video. We know it isn't released because the girl was underage and the content that is in it horrifies people. Well, there's a statement about her being underage. I don't think it's right for it to be shown to people, and it still is. I believe it is Jeanette in the video, but I can only tell by the index finger rings and bracelets. FBI got involved, and we've been working with them because unfortunately there were many more teens subjected to abuse. But mainly I found Sistina's live journal of you, Jeanette, and Allison. I know the police pulled them out of the band situation in New York at some point, and I know it's probably very weird to read about this from a complete stranger, but I felt compelled to check in because of the abuse suffered from other teenagers, and that there's a group here if you ever wanted that. But there's no pressure to be involved in any way, and I recognize this must be a hard message to read. Okay, so one potential issue I see here for Marilyn Manson is where she says, I believe Jeanette is in the video. If that is meant to indicate that she thinks that the person who was the focus of the video is Jeanette and not Paula Weiss, that could be a potential issue because that could get in the way of actual malice for the defamation claim. So in other words, for Marilyn Manson has to prove not only that Illma Gore is lying about the actress being dead, the actress being underage, but also that she lied with actual malice, knowing that what she said was false, or with reckless disregard as to the truth or falsity of the matter. So if she actually reasonably believes that it was someone else, she could have been mistaken as to the identity of the person, if that's reasonable, right? If there's if it's easily verifiable elsewhere, like who the person was in the video, because it's like on IMDb, for example, that could be a different kind of matter. But I don't know. I don't know enough about it. But that is something that potentially gets in the way of Manson's claim. Now, does that get in the way of him being able to overcome the anti-SLAPP motion? Not necessarily, because he can still introduce other evidence to say, no, she knew who she was talking about. She knew exactly what she meant, and she knew that she was lying. If he presents that, that information, whether or not there's a dispute, whether or not it's a gray area, doesn't necessarily matter for purposes of the anti-SLAPP motion, so that this case can continue forward towards trial. So, but in terms of him proving liability, that could potentially get in the way. Okay, Exhibit E. Jackson Trugmans. This is an email between lawyers, it looks like, regarding Evan Rachel Wood. Okay, so this is going to the conversations between the lawyers going into the ex parte application. So to answer Edwin's generation, to answer your question, how could that be proven if this evidence shows otherwise? You have other evidence showing otherwise. In other words, you could say that someone could say, Illma Gore came up to me and talked to me about the groupie video, and she said she knew it was Paula Weiss, and Paula Weiss was underage and she's dead. You know what I mean? Like someone else could say, yeah, but in another instance, she said otherwise, which could indicate she knew what she was saying. She was just lying to this particular individual about who that person was that was in the groupie video, specifically by their name, if that makes any sense. So, but yeah, a good question. Who are these DMs to? I think they indicated in the declaration itself, but I wish it was more obvious from looking at the actual screenshot. Okay, so I'm going to exit out of here and we will go on to the next declaration. Okay, let's see here. Where am I? Sorry, guys. Okay. All right. Okay. Declaration of Blair Burke. Okay. I'm an attorney licensed to practice law in the state of California and serve as counsel for Brian Warner, professionally known as Marilyn Manson. The following facts are within my personal knowledge, and if called as a witness herein, I can and will competently testify thereto. On or around November 2021, I became aware of a letter purportedly written and signed by an agent Michelle Langer of the Federal Bureau of Investigation, FBI, concerning a purported federal criminal investigation into Warner and a supposed threat to the safety of Evan Rachel Wood and others. Oop. Thank you. I need to update this banner. Thank you so much. There we go. Sorry, guys. Thank you. Okay, yeah. This is the declaration of Blair Burke. A true and correct copy of that letter is attached as Exhibit A. I had immediate concerns about the authenticity of the letter based on my nearly 30 years of experience practicing federal and state criminal law because the letter, purportedly written on behalf of a federal law enforcement agency, was not printed on official letterhead. The correspondence stated the author was from the Federal Violent Crimes Department, a department, quote unquote, I had no knowledge of and quickly determined did not exist. The correspondence was not addressed to a specific person and handwritten contact names on it, and also contained glaring typographical errors. That's a lot of reasons to suddenly have an immediate distrust of a particular document. And I would agree. I've got the same concerns looking at this FBI letter. On or around January 26, 2022. At my direction, my office undertook efforts to determine if there was an actual special agent for the FBI named Michelle Langer. Contemporaneously, my office called the telephone number attached to Agent Langer's name on the letter. A woman named Michelle Meyer answered the phone. Meyer told my office she was not a federal agent and was not Michelle Langer, but was instead an acquaintance of Mr. Warner. After determining that the FBI did employ a special agent by the name of Michelle Langer on or around February 2nd, 2022, I called the Tampa Bay field office of the FBI. The dispatcher I spoke to located FBI agent Michelle Langer in that office. I was connected to Agent Langer, who answered the phone. During this call, I described the letter and emailed Agent Langer a copy of it. Agent Langer told me she believed the letter was likely a fraud based on my description of the letter. I told Agent Langer I represented Brian Warner, professionally known as Marilyn Manson, and asked if she was familiar with this person or had ever been involved in any criminal investigation of Mr. Warner. Agent Langer said she recognized the name but had never investigated Mr. Warner or any matter related to Mr. Warner. Agent Langer also stated that she had not ever investigated any matter related to Evan Rachel Wood. After receiving and reviewing the letter, Agent Langer confirmed to me that 1, she did not write the letter, 2, she never authorized the contents of the letter, 3, she never authorized any use of her name on the letter, and 4, there is no federal violent crimes department at or associated with the FBI. During this call, I also asked Agent Langer whether she recognized the name Illma Gore, aka Ashley Gore. Agent Langer stated the name sounded familiar and that she believed that Gore had previously contacted Agent Langer to report a crime unrelated to Mr. Warner. Huh, that's interesting. I'm curious as to what crime that actually was. But so so one of the things that was so incredibly convincing in the Depp v. Heard case was when you had third parties that have absolutely no dog in the fight whatsoever, and particularly who have a duty to tell the truth on these kinds of matters. I'm talking about law enforcement. The law enforcement, the LAPD officers that testified in the Depp v. Heard trial, for me personally, were incredibly convincing to show that Amber Heard's allegations about the domestic abuse on May 23rd, 2016, or whatever that date was, that was all a hoax, right? That for me was particularly convincing because what reason do they have to lie? And in fact, they have arguably a responsibility. They would want to tell the truth. If they don't have an interest one way or the other, they're going to be pretty reliable witnesses. For Marilyn Manson, this is a damn good witness. If they are able to get this particular individual as a witness for trial, bringing them in through deposition, bringing them in person, bringing Michelle Langer in person to trial to testify that this letter is a complete hoax. That is damning information for Evan Rachel Wood and Illma Gore. At least to show that this letter is a farce. Then the question becomes, if Evan Rachel Wood and Illma Gore didn't write it, who did? Right? So even though when it comes to trial, the burden is on the plaintiff to prove their cause of action, that introduces a very, very enticing question for the jury to be answering. And so the defense, even though they don't have the burden at trial, you still want to introduce some other narrative, some other story for what does adequately explain this. Because if you don't have a good explanation for it, and you've got some really damning evidence to show that this is a fake letter, that's really bad for Evan Rachel Wood and Illma Gore. So anyway, and that's of course where Briton Gore comes in. And so this, regardless of not regardless, but keeping in mind Briton Gore's potential credibility issues that are there's a fight going on Twitter right now for that. This testimony from Michelle Langer would definitely bolster Briton Gore's testimony about saying, look, I saw all of this and everything kind of checks out on a timeline. And so even if Evan Rachel Wood's and Illma Gore's side, they bring out all kinds of damning stuff about her having issues with stability, having issues with her having a vendetta against Illma Gore. There could be reasons that they bring up, for credibility issues against her. There's a chance that couldn't necessarily have an ultimate impact on her testimony if everything she says lines up with someone who is a damn good witness. And this would be one. So for Marilyn Manson, this is a huge score to have this particular witness here. Okay. Okay. And I'll answer this too. Alon says, sorry if I missed it, but could you explain what makes a witness credible or not? Well, a number of things. We've got to figure out whether, I mean, ultimately the credibility of the witness comes down to the question of, can we trust that what this witness is saying is true and accurate and correct? Do they have any perception issues? For example, if you've seen My Cousin Vinny, great example when they've got the old lady testifying that she saw the defendant murdering the guy in the store or what have you. It's been a while since I saw it, so I apologize if I'm fuzzy on the details. But the part that is most important there was how the defense attorney, of course, walks back. He has her take off her glasses. He says, "Were you wearing your glasses on that day?" "Yes, I was." "Okay, or no, I wasn't, I guess." And so he has her take off her glasses and he walks across the room and he says, "How many fingers am I holding up?" And she says like the wrong answer. Perception issues. That's one issue that can come up with a witness is this the kind of witness that could have possibly seen? Was there, if they're talking about witnessing a murder, was it dark out? Was it light out? Was there fog? Like things that could have in the moment interfered with their ability to take in that information. Then you have issues of bias or memory. Those are two separate issues. Memories fade over time. You can get, you can have your like your knowledge or your perception of specific events change over time. Trauma has a tendency to change your memory as well. I mean, if you are old enough to remember 9/11, how much of 9/11 do you actually remember? Were you in New York City or were you across the country or across the world, for example? When those things happened, that can also have an impact on how much trauma you felt from that day. But even without the trauma, over time, your memories fade as to what you actually remember from that day. And I talk about this a lot, but Malcolm Gladwell I think it was on his revisionist history podcast, where he actually talks specifically about that day and having a conversation with his neighbor and how the two of them were like, no, like you got this conversation wrong. You were talking about flying. I was talking about not flying. Like so many things that over time your brain just forgets certain things because either it's making room for other memories that are deemed more important, or if it's particularly traumatic, the brain also wants to protect itself from harm. So anyway, um so that's memory issues. Then there's also bias. So if someone has a particular reason to lie about another individual, if they have a particular vendetta against them, I think that is one thing that Brighton might have to be concerned about, not be concerned about, but that Manson's attorneys would be concerned about sort of defending against or shaping or crafting to prevent the jury from saying, okay, but this is a particularly biased witness against her sister because she's got a history with her. So anyway, so those are some reasons for that could impact the credibility of a witness. I hope that answers your question. Okay. Alrighty. Where was I? Did I read paragraph 5 here? I think I did. Okay. Yes. Okay. Paragraph 6. During this call, I also asked Agent Langer whether she recognized the name Illma Gore, aka Ashley Gore. Agent Langer stated, Agent Langer stated the name sounded familiar and that she believed that Gore had previously contacted Agent Langer to report a crime unrelated to Mr. Warner. On or around February 3rd, 2022, I spoke to Agent Langer again. During this call, Agent Langer also confirmed that there was, in fact, no criminal investigation of Mr. Warner being conducted by the FBI. Discussing the letter again, Agent Langer stated that she had a suspicion of how her name had been wrongfully used. Two individuals, Mitch Emerson and Kelly Blousechild, had previously contacted her office to report a crime unrelated to Mr. Warner. Like Gore, Emerson and Blousechild are involved with the Phoenix Act. Ruh-roh. Emerson is listed on LinkedIn as the executive director of the Phoenix Act and has posted to Twitter that he works with the Phoenix Act. A true and correct copy of those web pages are attached as Exhibit B. A Kelly Blouse, believed to be Blouse Child, is also listed on LinkedIn as the communications liaison of the Phoenix Act and has posted to Twitter that she works with the Phoenix Act. Another web page at kellyblouse.com/vision states that my name is Kelly Blousechild. I have worked with the organization called the Phoenix Act. A true and correct copy of those web pages are attached as Exhibit C. Okay. Interesting. There is a connection here. I understood from my conversations with Agent Langer that at the time, she was not authorized to prepare a declaration in a civil action stating the above facts because of the ongoing investigation of the letter by her office and the U.S. Attorney's Office. So they're actually investigating that particular letter. Okay. So that would be her reason for why Michelle Langer is not willing to sign a declaration, in which case they would have to get a subpoena. Interesting. Very, very, very interesting. So I do understand that the opposition papers that were filed by Evan Rachel Wood and Illma Gore, they also mentioned other investigations that have been happening by the FBI or by, I should say, by the LAPD as well. It'll be interesting to see what they say about those specific investigations. But regardless, even if there are other investigations, this could be particularly damning. Because this is what looks like an incredibly fake FBI letter. I personally want to wait until seeing sworn testimony from Michelle Langer, FBI agent Michelle Langer, before concluding that this is 100% an FBI hoax. But it looks a lot like a hoax letter. It looks fake. It looks fake as all get out. It really does. There's no letterhead. There are all kinds of typos, of errors. There's a phone number that reaches a different Michelle. Yikes. Okay. Declaration of Esme Bianco. Esme's? I hope I am pronouncing that correctly, as always. Okay. Okay, starting from paragraph 2 here. Declaration of Esme Bianco. I met Brian Warner, professionally known as Marilyn Manson, online in approximately 2010. 2010. I was a fan of Manson's living in Hungary at the time. In January 2011, I spent 3 days and 2 nights in the company of Marilyn Manson while he was visiting Vienna for an art exhibition. During that trip, I communicated with Manson's personal assistant, Ashley Walters, who was traveling with Manson, and coordinated our meeting. When I arrived at our hotel in Vienna, she met me in the lobby and introduced me to Manson. When Manson was at the hotel, I stayed with him in his room, and when he was out, I stayed in Walters' room. I have not seen Manson or Walters since that weekend in January 2011. On October 15th, 2020, and January 22nd, 2021, I received emails from Illma Gore, Illma@thephoenixact.com, sent through my website. A true and correct copy of those emails are attached here to as Exhibit A. The messages from Gore said in part, I know this is a strange way to reach out, but my name is Illma. I work with the Phoenix Act alongside Evan Rachel Wood. We were organizing a group of people to meet up in Los Angeles and Zoom/Skype in to talk about experiences they had that might be similar to yours. In approximately February to May 2021, I became aware through media coverage that lawsuits had been filed against Manson, including by Walters. I reviewed Walters' complaint at the time, in which Walters states that she witnessed defendants' constant degradation of female fans, citing one example, the January 2011 trip to Vienna. I reviewed her further statement that while in Vienna, defendant met with a young girl. After inviting her to his hotel room, he bragged about having sex with her. He also texted Walters from his hotel room, saying he took the girl's virginity. Walter's description of my time with Manson and Walters in Vienna is false. I was not degraded, humiliated, or abused by him. And while I did have sexual intercourse for the first time with Manson, I consented to and enjoyed everything that happened between us that weekend. I was also not a quote unquote young girl at the time. I was 19. I was a 19-year-old woman. I was deeply disturbed by Walter's filing and Gore's emails. Not only had my story been taken and misrepresented by Walters without my knowledge or consent, but also I was being recruited by Gore as a supposed victim of Warner to join a group of people to talk about experiences they had that might be similar to mine. All of this was false, and I was not a victim of Manson. I did not attend any groups, quote unquote, organized by Gore or Wood. I declare under penalty of perjury under the laws of the state of California that the foregoing is true and correct. Okay. So, all right. So her story was misappropriated, it sounds like, and misrepresented. And I'll get to those exhibits in just a second. One issue here is I'm looking to see if there were any other entreaties by Illma Gore to amaze. Basically, does Illma Gore try to press on? Does she try to press further to say, like, hey, we really want you, come join us? I don't know. The fact that that's not in here doesn't mean that that didn't happen, but that's something that I would be looking for. Okay. Exhibit A. So that is the email on October 15th, 2020 from Illma Gore to Amaze. Okay, let's see if we can see this here. Can you guys see it? I know it's really small font. Okay. Hey, I know this is a strange way to reach out, but my name is Illma. I work with the Phoenix Act. I run it alongside Evan Rachel Wood. We were organizing a group of people to meet up in Los Angeles and Zoom/Skype in to talk about experiences they had that might be similar to yours. I'm not sure that you would be interested in participating. You aren't obligated to speak, but if you wanted to listen in, that would be fine. It's a small group and you are personally invited. If you wanted to know more first, I would be happy to jump on the phone or email more details. Best, Illma. Okay. And then we've got January 22nd. Hi, Greta. I'm close with Evan Rachel Wood. And this is from Illma Gore again. I want to reach out and speak to you on the phone on behalf of the Phoenix Act and very important information, if anything, just to listen. Best, Illma. Okay. And then this is the same email, but with okay, it's showing that this is from Illma Gore. Huh. I'm confused about this a little bit. It says mail@gretaaurora.com, but it says that that's Illma Gore. I don't know. I'm a little bit confused. Okay. Alrighty. And okay, that's it. Oh, okay. In Manson case, it says it shows the email sent via the website. So domain email forwarded to Gmail. Okay. Got it. This is me boomering a little bit with with some of this tech speak. Okay. So next we have, all right, Jaden Elworthy. We're going to go through this declaration. Okay. Declaration of Jaden Elworthy. Who is Jaden Elworthy? Oh, this one is very short. Okay. Paragraph 2 says, on or around May 22nd, 2022, I met Ashley Morgan Smithline in London, England, and spent some time in her company. She later contacted me on Instagram Messenger from the account Ashley Morgan Smithline to communicate about this time, which confirmed to me that this account and the person I met were the same. I declare under penalty of perjury under the laws of the state of California that the foregoing is true and correct. All right. Oh, sorry, guys. It's not up, is it? I will show it. Right here. Okay, so the only issue is I would like to see some images from those. That would be helpful, but I don't know, maybe they just weren't willing to share those images, those screenshots for the purposes of the declaration. I don't know. But this is something that I would have liked to see. Okay. But basically that's it. Basically saying this is her Instagram. I met her in London, England. Was it the first time? I'm a little bit curious about this person's the extent of this person's time with her. Okay. That one was very quick. Next up, Paula Weiss. And this time I will remember to share the screen, guys, because I am a professional. Okay. Okay. Declaration of Paula Weiss. I expected to say, I, in fact, am not dead. Okay. Paragraph 2, I have known Brian Warner, professionally known as Marilyn Manson, since the early 1990s. During that time, I knew Manson as a social acquaintance. I am a model and actress and have gone by the name Paula Weiss in my professional life. In approximately 1996, I was living and working in Los Angeles. I went on a casting call for a music video. I was cast for the role. When I arrived at the shoot, I was seated next to Manson at hair and makeup. The video was for his song, Long Hard Road Out of Hell. We became friendly during the shoot and thereafter engaged in a romantic relationship for roughly a few months. During this time, I became close to Manson and his band and spent time with them at Manson's home in Hollywood. Manson was never physically, emotionally, or sexually abusive towards me. During the same period in approximately 1996, when I was seeing Manson, I acted in a film by Manson called Groupie. So same time that she had this, about same time that she had this relationship with him. I was approximately 21 to 22 years old at the time. So it seems like she met him when she was already 21, 22. Youngest would be 20, right? Because if it was like, let's say her birthday was at the end of 1996, she met him early 1996. That she turned 21 at the end of 96 is what I mean. Okay. Before the film was shot, Manson and I discussed his burgeoning interest in filmmaking. We discussed his concept for the film and some high-level dialogue that he had drafted. The film would be shot at his house. We agreed that I would play a crazed fan, i.e. the groupie, who found out where Manson lived and was bringing him a piece of art. His bandmates would be at the house when I rang the doorbell. The scene was then to devolve into a scary game of truth or dare, straight out of a horror film. Only he and I would be in on the plot, and part of the concept was to capture the reactions of his bandmates and other people who were in the house. I feel like this is like another version of Punk'd that had Ashton Kutcher, or Jackass or something. Like, I feel like this was a trend in the 90s, if I remember correctly, or maybe 2000s, like early 2000s or something, where people would film candid reactions with like outrageous incidents. Right? Let me know in the chat or in the comments if you're watching on the replay, if you remember those kinds of shows, and if I'm right about the time span on that. Before, during, and after the film shoot, I knew what I was doing and was totally comfortable with it. I fed on the energy of the shocked crowd and hammed it up for the scene. I felt completely and totally safe during the filming with Manson. I did not feel degraded, humiliated, exploited, or abused. It was acting make-believe. In fact, I felt like I was able to give into the character and further develop my acting skills. I considered this film to be a professional job. It was a paid job, and the film was shot by acclaimed director Joseph Coltis. I have seen the documentary of Manson's 1996 tour titled Dead to the World, which was also directed by Coltis. A short clip of the groupie film I acted in was used in the documentary, and I was thanked in the credits. Special thanks, Paula Weiss. Any statements that I was under the age of 18 at the time groupie was filmed, that groupie depicted or constituted child illicit material or abuse, or that I was dead or killed are unequivocally false. She is not writing from beyond the grave, in other words. I have never been contacted by Illma Gore or Evan Rachel Wood regarding my relationship or work with Manson. And this is also under penalty of perjury. All right. No exhibits to this one. But that basically says what I expected it to say. Let's move on to the very last declaration here, which is, whoops. Alrighty. Dominic Phoenix Skaya. Okay, I see in the chat that Eric Hunley has some pictures of the Instagram messages. That, yeah, I'll reach out to him and I'll ask him where he got those, because that's very interesting to me. I have seen those, I think, around Twitter. I know that those have been shared around. I'm trying to take what I'm saying straight through primarily these filings for now, but I am willing to look at other stuff. I've seen other materials around Twitter and around YouTube and elsewhere that are other aspects of this particular case and other allegations that people are making about Manson, about Evan Rachel Wood. So I'll be looking at those as well. But Eric's great. I'll reach out to him and talk to him about those too. Okay, declaration of Dominic Phoenix Skaya. This is another short one. Well, except for exhibits. Okay. Oh, these are probably the messages. Okay. Okay, Dominic Phoenix Skaya, aka Phoenix Thorn. I do not know Brian Warner personally, but over the last approximately several months became interested in his legal cases and have followed them online. I run the Instagram account Marilyn Manson is Innocent. On June 6th, 2022, I started a conversation over Instagram Messenger with Ashley Morgan Smithline from my account Marilyn Manson is Innocent. During our conversation, which extended through June 2022, we exchanged text, audio, image, and video messages. I shared pictures and details about myself. Attached as Exhibit A here too are true and correct copies of excerpts from my conversation with Ashley Morgan Smithline. Ah, I see. Okay, so I see why that other declaration came in. It was to authenticate her account as actually belonging to her, saying, I saw her in person, we hung out, we talked, and then she confirmed to me that this account was hers. And they're declaring that under penalty of perjury. So generally speaking, that is something that you can kind of rely on, because these declarations, although they're not a witness testifying on the witness stand at court, it's not a deposition, they're still signing under penalty of perjury, which is the same enforcement mechanism that you would have for a witness in a hearing or at trial or in a deposition. So basically what they're saying with that other declaration is to say, yes, that Instagram account is real. This is the person. I saw her in person and she verified to me that this is her. And then this particular declaration is saying, hey, so this particular account, which has been verified elsewhere, made these admissions. So let's move on to Exhibit A to see what that conversation was. So you can see here, Ashley Morgan Smithline on Instagram. And so the purple boxes, it looks like, are from the Marilyn Manson is Innocent account. And then Ashley Morgan Smithline is in the black boxes in between. Okay, so in purple, you're not. You're beautiful. You looked really good in that People magazine interview. So pretty, okay? I can feel your sorrow. I'm so sorry you're struggling so much. And then Ashley responds, they told me to lie and act and speak with no accent. It was truncated. And then in purple, why did they make you speak in an American accent out of curiosity? And then Ashley says, be like Evan. And then in purple, oh, I see. That's weird. There's already one of her. You could just be like you. That makes me sad. And then Ashley says, I just want to keep working and be myself. Myself. This to me sounds very, I don't know, British, Australian, perhaps. Definitely not an American term that is normally used. And then she says, and then Ashley further says, I got pulled into this whole cancel thing and I just want to keep working and carry on living me own life. V. Maybe that's a type of V, but and then in purple it says, that's completely understandable. Have you been doing okay? This has got to be a pretty heavy burden to carry. And then Ashley says, it wasn't something I knew I was even being brought into. I never wanted to cancel anyone and I just fell in with influence. I want to work and move forward. And then in purple, it says, you're not a bad person, though. You just do what you need to do to survive in life, right? Even if you have to be dishonest sometimes. I'm willing to bet that you never actually try to hurt anybody. You never actually want to hurt anybody. And then Ashley says, I wouldn't actually hurt a fly. I have no anger or malice. And then in purple, it says, are you sure you're not Australian? And then Ashley responds, Evan's documentary narrative just needs a certain spin for her billions. Whoa, boy. And then in purple, it says, the one thing about this is that this is starting to look different. These purple boxes are starting to look different. I don't know. I know that as you scroll up on iMessage, for example, the shade of blue changes. So this could be just that happening. But it does look a little bit strange here. Okay. And then in purple, it says, and then I saw you on the news, LMAO, and you so did not want to be there. He kind of looks like you'd been awake for like 3 days straight and were possibly on like 6 caffeine pills. You looked, and then bloody speech to text. And then Ashley says, and ket, I think ket meaning ketamine, something like that. In purple, it says in response, LMFAO, you were on the special K while you did that interview. And then Ashley says, you should resent young girls who reenacted the Crucible. Crucible is a story that is a book that is read in usually high school literature about the, what's it called? Witch hunts. I've been live streaming for over 3 hours, so sorry, guys. The Salem witch trials. That's what that's about. Okay. In purple, it says, to be honest, you did seem a little strung out. And then Ashley responds in all caps, because it is my name. They destroyed me. I had to numb. And in purple, it says, all of you were roped into this. It looks like shit, though, because it's with S with stars. It was all Evan's, sweetheart. And then Ashley says, Esme and media and Illma, to be fair. Okay, interesting. And then in purple, good acting is one thing Evan has going for her. Ashley says, but they really let me be Patsy and take it worst. I left country. Then in purple, yeah, the media was also roped into this. Evan had a lot of power here. She controlled everything. And then Ashley says, I can't exist in that cruelty. People take the purest, kindest souls to take falls. And then in purple, I know, sweetie, but we're going to clear your name one day, yeah? Ashley says, I'm no angel, but it's just not okay. And then in purple, I know you were gullible and a people pleaser, and you thought you were doing the right thing. Did you really think that by lying, making up your own story, you would be helping her? Yeah, I hate lies too. I can't stand telling lies, and I can't stand injustice. I always got to do the right thing, even if it hurts me in some way. I usually end up feeling better after anyway. And then Ashley responds like, I've fallen for someone and we went about it as adults. We wasn't supposed to, but 3 days in, we owned it and took lashing, took blame and consequence. Your heart chooses what it does, and life is already written. Woo! Whoa, boy. Also incredibly damning. Also very, very, very damning about this conspiracy issue. This is something that Ashley Morgan Smithline can expect to be deposed in this litigation moving forward, because I'm at this point, I think that Manson is probably going to be able to, I mean, I said this before, but now after looking through this motion, it'll be interesting to look at the opposition papers for this motion for limited discovery. But I am pretty convinced that he's going to win this motion. He's going to be able to conduct limited discovery in order to have his chance to show his prima facie case to combat the anti-SLAPP motion. He's probably going to be able to overcome the anti-SLAPP motions, at least the one against Evan Rachel Wood, the one against Illma Gore, the actual malice piece, possibly questionable, but he doesn't have, like I've said before, he doesn't have to prove defamation at this point. He doesn't have to prove IIED at this point. What he has to prove is that he has a probability of being able to prove later on. Basically meaning that he has enough that he can probably show more to put it in front of a jury. But if all of that happens, Ashley Morgan Smithline is getting deposed. She's going to get grilled. She, if this goes to trial, she's getting put on as a witness. And she really needs to choose for herself where she wants to stand at the end of this, because one way or another, I mean, the account Marilyn Manson is innocent. Sorry, Dominic Phoenix Gaia. Sorry. Dominic is probably also going to be deposed, probably also going to be potentially called as a witness. And so you're going to have multiple people talking about this conspiracy and her admission to the conspiracy, or so Dominic would be possibly as a rebuttal witness, I suppose. But anyway, at any rate, Ashley Morgan Smithline is in a very precarious position in this litigation, because there are text messages showing her admission that this is a hoax, that she, allowed herself to be manipulated by Evan Rachel Wood and Illma Gore. In my opinion, there's enough here to not only get the discovery that Marilyn Manson needs for the anti-SLAPP motion, but then also probably to actually win the anti-SLAPP motion. And this is probably going to be proceeding further. Okay, with that, I think that's about it. And I apologize, you guys, that my camera for some reason has been this whole time has been filming me with such terrible resolution. I don't know what's been going on with that, because clearly it's not so bad. My connection is not so bad that, like, banners, for example, are showing up clearly and the document showing up clearly. So I don't know what's going on with StreamYard, but anyway, we dealt with it. Most important was the documents anyway. So what do you guys think? Do you guys think that, number one, do you think Marilyn Manson is likely to get the discovery that he needs for the anti-SLAPP motion? Do you think that he is going to possibly win this anti-SLAPP motion? I feel like these are all leading questions because of what I already said about myself, and my opinions and my thoughts. But if you disagree with me, tell me why. I would love to hear it. Otherwise, tomorrow I anticipate going over the opposition papers that were filed for this motion, the opposition papers filed by Evan Rachel Wood and Ilma Gore. We'll go over those. See what are their best arguments against Marilyn Manson being able to conduct some limited discovery. Do they have any good arguments? Do they not? Okay. All right. This has been a long one. I appreciate you guys hanging out with me. Otherwise, I'll see you guys tomorrow. I'll see you in the next video. Oh, wait, actually, before I do that, sorry, I've got a couple super chats. And I totally did this yesterday, by the way. I forgot a super chat, which I actually should go back and reread. I'm so glad I just remembered that. Okay, hang on. Okay. Let me see here. Okay, there was one from Art Norman Jr., an author, who says, "Hi, Alita. Thanks so much for the super chat, Art Norman Jr. Says, "Hi, Alita. I followed you during the Depp Heard saga. Great show. My ebook, Hollyweird, Yorkshire Publishing, Cali, Avail, Amazon." So it sounds like they are also advertising their book through super chat. That's fine. That's okay, I guess. T in Tennessee, thanks so much for the super chat. Says, "This and others make me wonder how rampant these situations are." I don't know, man. And then also Talking Insecurity. Welcome to Bike Club. Thanks so much for becoming a YouTube Bike Club member. Otherwise, okay. I'll see you guys tomorrow, hopefully with much better resolution. See you in the next video.